Morning, Mr. Asmat.
Good morning. How are you?
I'm fine. How are you?
Good. I just need to speak to Rima, I'm sorry, on the Stevens disposal recycling case.
Okay, I'm not sure if it's going to be her or Mohammed this morning, but I will put you in their breakout room, okay?
Okay, thank you.
You're welcome. Good morning, Mr. Noakes.
Good morning.
How are you?
I'm doing well. How are you this morning?
I'm really good. It's good to see you.
Well, I'm glad I'm glad somebody's seeing me.
What case are you here for this morning?
I'm here for AJ Stovall for PCC, and the
Oh,
prosecutor on that case is Brittany Johnson.
okay. Okay. Are you going to need a breakout room with her when she gets here?
Not with her. I will, in all likelihood, need one with Mr. Stovall because I didn't have a phone number for him, so I'd like to talk to him.
Okay, you got it. When he gets here,
Thank you.
I will do that for you. You're welcome.
Thank you so much.
Sure. Mr. Noakes, just to let you know, that case is scheduled at 9 o'clock.
Okay. Well, I'll have to come back because I have a 9 o'clock in circuit court.
Okay, all right, we'll see you then.
All right. Thanks. Bye
You're
bye.
welcome. Bye. Morning, John. How are you?
I'm doing well. How are you?
I'm good. Thank you. You're here on DUR?
Yeah, Duran, I think I have Reigns as well. Nope, that's not me. Never mind. That's somebody else.
Oh, okay. So if they go into a breakout room, do you need to go with the prosecutor or do you need to speak with the
Uh,
prosecutor? Or you just
nah.
leave when you are?
Actually, yeah, I do need to speak with the prosecutor. I think it's a special one today, correct? For this
Um,
case. For this
that
case, I think.
I don't know the answer to that. Let me pull it up and see who it is. Hold on one second.
Okay.
John, I have a regular prosecutor, Mohammed on.
Okay.
No.
I'll talk with him, but he probably won't know what's going on with the case. I'll give him a heads up. That way he can inform them down there. So whenever he
Okay.
gets in, just put me in a breakout. That's fine.
Okay, I'll do that right now I'll put you in his waiting room.
Thank you.
You're welcome. Morning, Mr. Bissett.
Good morning. I'm here on Venetia Rains, and
Okay,
we'll be
go ahead. I'm
uh,
sorry.
and I oh no, I was just gonna say I'll be sitting in for a preliminary exam, so I don't know if I need to speak to the prosecutor or not to do that part.
Sure. Yep, I can put you in the breakout room.
All right, thank you.
You're welcome. Good morning, Mr. Riggins.
Good morning.
Hi
I'm
there.
here. I'm here on James Bailey and Jayla Wilkerson.
Okay. Do you need to speak with the prosecutor?
Um,
I think
sure.
we're good for Bailey.
Oh, hi, Patricia.
Oh, sorry, I didn't mean to interject. Hi.
What, I'm sorry, what did you say, Patricia?
Oh, I said I think we're good for Bailey.
Okay.
Okay.
Mr. Riggins, do you need to speak with the prosecutor on Wilkerson?
No, I have all the discovery. I spoke with my client. We're just going to set up a preliminary examination.
Okay, thank you. Mr. Riggins, do you need to speak with your client or are you all set?
I spoke with her the other day, but she did try to reach me this morning. If you want to put me in a breakout room,
I will do that.
Thank you.
You're welcome. Ms. Wilkerson, you're going to see an invitation to join a breakout room. Morning, sir. How are you?
I'm good. How are you?
I'm good, thank you.
I've got Durr
Yep. Okay.
in the jail.
Yeah, and you know, the jail is not here yet. When they do get here, do you need to speak with your client or do you need to speak with the prosecutor?
I need to talk to the prosecutor. Has Mr. Ryan Lukeski signed in? Because he's
No.
the assigned prosecutor on this case.
No, he hasn't, not yet.
Okay, well, if my client becomes available before he does, I'd like to meet with both of them. So whichever one you want, I'll talk.
Okay.
Okay.
All right, sounds good. Thank you.
Thank you.
Mr. Riggins, are you ready with your client?
Yes, which one?
Okay. Oh, sorry, Miss Wilkerson. Mr. Bailey isn't here yet.
Mr. Bailey is in Wayne County Jail.
Yep, they haven't signed on yet.
Okay, but yeah, I'm ready on Wilkerson.
Okay, thank you.
Mhm.
Just so you know, Judge, Mr. Mohammed is in Judge Green's Zoom, so Michelle is trying to get his attention to send him our way. Our a prosecutor.
I really wouldn't expect anything different on a Wednesday. That being the case, let's go to 230761 FY. This would be State of Michigan versus Jayla Wilkerson. Your appearances, please.
Good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggin, P82125 on behalf of Ms. Jayla Wilkerson. Wilkerson, can you state your name for the record, please?
Jayla Wilkerson.
Your Honor, date and time set for a preliminary exam, for a PCC in this matter. We are in possession of all discovery. We'd like to set this matter for a preliminary examination.
Thank you, Mr. Riggins. Oh, Marianne, I thought this case was ready.
Yes, I thought it was being set for an exam.
We are.
This is is this a case with Mr. Mohammed? That exam date, Mr. Riggins, will be?
It's going to be January 17th at 12 o'clock.
That's fine, Your Honor. Thank you.
Thank you. Ms. Wilkerson, your in-person preliminary examination is set for January the 17th, 2024 at 12 p.m. That's here in courtroom number 1 at the 34th District Court. Notice will be mailed to you at the address that we have on record. Mr. Mohammed, is there anything else in the Wilkerson matter?
Nothing from the people, Judge.
Anything else, Mr. Riggins?
Nothing further, Your Honor. Thank you.
Thank you. Ms. Wilkerson, that concludes this matter. You're free to go. You have a good day.
Thank you.
Good morning, Ms. Oliver.
Good morning, Your Honor. How are you?
I am super. How are you?
Okay, I'm doing great. Thank you. Good morning, Your Honor. How are you? I'm just going to interject here, Your Honor.
I am
And
wonderful, Ms. Medina. How are you?
Good. I want to explain myself for a second, Your Honor. I haven't logged on to Zoom yet because Daniel Bitar is so amazing. And he told me this morning I needed to be in person here. I was not planning for that. So I ran over here to be here in person, but now I don't have a laptop and everything's on Zoom. Should I go back to my office? This is crazy. So did I need to be here in person, I guess is my question, or via Zoom, like I had initially?
Not for me.
Okay. Okie dokie. Alrighty, so
My
I'm gonna try to
apologies
figure
for the
this out.
miscommunication.
No. I'm just trying to figure out what would be best right now. Me rushing. I don't have a laptop, so I'm trying to see what's the best way to do this now. Okay. All right. Thank you, Your Honor.
You're welcome, ma'am.
Good morning, Mr. Mohammed. Oh, good. He went in his mouth.
Judge?
Ma'am?
I'm sorry, Judge. Is it okay if I head back to my office? It'll take me about 15 minutes to get there and I'll log in from my office in that case.
Absolutely, Miss Medina. Thank you for letting us know.
Thank you so much. And I'm sorry for the confusion, Judge.
No worries.
And it does say in person on our sling, so Daniel was watching out for me as always, but we're confused. Thank you.
You're welcome.
And yeah, if I may, I'm going to log off of this device and log on from another device in about 2 minutes, if that's fine.
Yes, sir.
All right. Thank you.
Thank you. Mr. Chirikian, I know we had the issue last week with the special APA not logging on. Have you been in contact with that person?
No, Judge, I haven't heard from him.
Good morning, sir.
I'd also like to note I have incomplete discovery, Judge, and that is an issue I'll bring up with the prosecutor.
Understood. How are you this morning? Super. They're on your desk out there in the orange pile. I brought them out this morning.
Hey, Judge,
This
we're ready
is-
on rings.
I'm sorry, Mr. Mohammed.
I was just letting you know that we're ready on rings whenever you are.
You're ready on the case that I'm calling right now?
Oh, sorry.
That's okay. Mr. Mohammed, what I do typically is when the attorney is out and I see the client, that's the case I call, even if it's not time for it. So,
Okay.
good morning, Mr. Kaplan.
Good morning, Your Honor.
This is 230830 FY, State of Michigan versus Vanisha Rains. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Ms. Venetia Rains, who's also present by Zoom video, Your Honor.
Ma'am, unmute yourself and state your name for the record, please.
Vanisha Rains.
Thank you. Today's the day and time set for the PCC. Mr. Basant, how are we proceeding this morning?
Judge, I wanted to set this for a preliminary exam. And just to let the court know, Judge, I was going to ask, my client resides in California. I was going to ask if she could still appear by Zoom. I can appear in person, but I was going to ask if she could appear by Zoom, Judge, if possible.
Mr. Mohammed?
Based on the circumstances me and Attorney Basant spoke about earlier, I would have no objection to that in regards to this matter. I
Thank
believe
you.
in this case, there will be a waiver.
The defendant may appear by Zoom for the preliminary examination. That examination will be set for January the 17th, 2024 at 12:30 p.m. It will be in person.
Judge, if I may, I don't mean to interrupt, but I start a CSC first degree trial on the 16th, and it's going to run from the 17th, from the 16th to the 19th.
Mr. Basant, always interrupt me when it's a time that's not good for you. That my next date after that will be February the 21st.
That's perfect for me, Judge.
February the 21st, 2024 at 11:30. Is that it, Mary Ann? 11:30?
Yes, ma'am.
At 11:30 a.m. here in courtroom number 1. I'm sorry, Mr. Basant, I did not ask, and I don't believe that you said, is discovery complete in this matter?
It is, Judge. I have full discovery.
Thank you. Ms. Rains, notice will be mailed to you at the address that you verified with court staff for a preliminary examination, February 21st, 2024 at 11:30 a.m. here in courtroom number 1. Notation in the file that the defendant may appear by Zoom. Is there anything else in this case, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Basant?
Nothing for defense counsel. Thank you, Judge.
Thank you. Ms. Rains, you're free to go. You have a good afternoon. I'll see you in February.
Thank you.
Either way. It's only a preliminary thing just to say we want all the evidence of the police.
Good morning, Ms. Frederick.
I'm not kidding.
Good
I'm
morning.
telling you,
How are you, Judge? Hold on a second.
I'm wonderful. How are you?
I'm fine, Judge. My client, Matthew Sedlak, was with you. And so now I'm kind of confused. I was informed by my colleague that he's now with Judge Oakley. Is that the case, or are we still with you?
It's on my docket for 9 o'clock this morning, unless you know something I don't know.
No, it's just a colleague that entered the wrong information. We're good. I'm glad I'm here. And my client is in both courtrooms as well. So I'm gonna log out of Judge Oakley and into your courtroom only.
Why would they think Judge Oakley?
I don't know. They stood in for me. I had I had an exam on that day. So the notes, I don't want to assail their character. They could have just been in both courtrooms and got confused.
Thank you.
Thank you, Judge, but we're here.
Yes, ma'am. Mr. Shuriken, we just received information that the jail will be logging on at 9 a.m.
That's fine, Judge. Thank you. Appreciate it.
You're welcome.
And Your Honor, would that apply for James Riley as well?
If he's in Division 2,
He is.
then that would be the answer to that as well.
Okay.
This is 230886 SM, State of Michigan versus Stephanie Lucas. This case was scheduled this morning for pretrial. The court received notice yesterday that the defendant was unavailable. And this matter will be adjourned. The pretrial will be adjourned to December 20th, 2023 at 9 a.m. live in courtroom number 2 with Judge Oakley.
Thank you, Your Honor.
You're welcome, ma'am.
The host opened breakout rooms.
Sir, are you Mr. Sedlak?
Yes, ma'am.
Thank you.
Sorry, Marianne, wasn't fast enough.
No worries.
Ma'am, did you need to speak to Mr. Mohammed regarding Mr. Sedlak?
I would love to, thank you.
Could I get access to the MIDC waiting room? My client's sitting in there. Miss Grove.
You bet.
Thanks.
Let's make Mr. Kaplan co-host so he can move around, please.
Thank you.
Good morning.
Good morning, Mr. Martin. How are you?
I'm good, Judge Martin. I see my client, Mr. John Woolley, here. I haven't had a chance to speak with him yet. Could I get a breakout room?
Absolutely.
Thank you.
And Your Honor, I can tell you the Wayne County Jail Division 2 Annex Low MC5, that is Mr. Bailey.
Thank you, Mr. Riggins. And you've already spoken to Ms. Mandernack.
No, I have not.
Would you like to speak with her?
Well, when we logged on, she said we were ready for the case, so I don't want to be presumptuous, but I think she already has in her mind what she's going to do.
Well, this is the issue for me. We're sitting here with all these attorneys and prosecutors, and if there are people who need to speak to each other, they should chat each other, chat Marianne, ask to be moved somewhere. Ms. Mandernack, for the Bailey matter, would you like to speak to Mr. Riggins?
I don't think I need to, Your Honor, but since he is here, I will.
Thank you.
Mr. Noakes, do you need to speak with Johnson?
Whoa. Excuse,
I'm sorry.
excuse me, I couldn't hear what you were saying.
Do you need to speak with the prosecutor?
No, I just need to speak with Mr. Stovall when he comes on.
Got it.
Thank you.
Excuse me, Judge, is Mr. Durr available at the jail? I can speak to him before I speak to the prosecutor if possible.
Absolutely. This is 230685FY, State of Michigan versus Matthew Sedlak. Your appearances, please.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. Lisa Frederick, P53372 on behalf of Mr. Matthew Sedlak.
Could you state your name for me, please, Mr. Sedlak?
My name is Matthew Sedlak, ma'am.
Thank you. Today is the day and time set for the adjourned PCC. Ms. Frederick, how are we proceeding this morning?
So I appreciate the opportunity to speak with Mr. Mohammed. We discussed the logistics of proceeding. My client is in an inpatient facility in Ohio, as the court may be aware. We agree that it'd probably be in his best interest and in the interest of justice to push the PCC one more time so that he could be present for an exam at some point in the future. I believe his discharge date is mid next year. And I would like to confirm with him. I think he's in the room with his caseworker who could give us more information on that.
Yes, ma'am. My discharge date would probably be next year, October.
Right. So this is why I was hoping that the court could kind of accommodate. I think that it would be in the interest of justice and in my client's interest to be present.
Mr. Mohammed?
Judge, it's been brought to my attention that this person is seeking a alcohol treatment program, and for him to have to be there for, over a year, I believe it's serious. I don't want to be a reason to interrupt that program. Our job at the end of the day is to help people, and if you believe that he should stay there and it's what we need to do, I have no objection into adjourning this to a future date.
Let's adjourn the PCC over to, did he say October release date?
Yes, he did, Your Honor.
Let's put it over to February the 21st, 2024 at 9 a.m. by Zoom. More status and check-in than expecting anything else. I just don't want it, I don't want to go too much longer than that without at least having the parties come back.
And Your Honor, can you do that date one more time?
I'm sorry, February the 21st.
Okay.
2024 at 9 a.m. on Zoom back here with me. Making notation in the file that the anticipated discharge date is October of 24. And if we can continue to check in every 2 to 3 months, just to make sure there's not some update or some change or some different direction of the case.
Really appreciate that, Your Honor.
Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Ms. Frederick?
Nothing, Your Honor. Thanks so much.
Thank you. Mr. Sedlak, good luck to you, sir. I'll see you in February.
Yes, ma'am. Thank you very much, too.
Mr. Chirikian, I've reached out to the prosecutor's office and asked them to see if they can get either that special prosecutor on or someone else authorized to stand in so that we may get your client's case called and get you on with your morning.
That's great, Judge. Appreciate it. But I was put in a breakout room with someone other than Mr. Durr. I need Mr. Durr.
I'm sorry, sir.
That's okay.
Okay. Judge, in regards to Mr. APA Ryan Lewinsky's case, I'm happy to step in, but if bond is going to be addressed or this is regarding something that requires his attention, I think maybe we need to adjourn this.
No, not when he's failed or when they failed to appear for a second time. If you're not going to come for a case you're scheduled for, you need to send sufficient information to the prosecutor who will be appearing. It's not fair to Mr. Chirikian to keep adjourning a case.
I understand, Judge. If I may speak to Mr. Chirikian in private, I can try to address the matter.
He's in with his client, so when he comes out, we can put you in with him at that time.
Okay, thank you.
This is 230870FY, State of Michigan versus James Bailey. May I have your appearances, please?
Morning, Your Honor.
Christian Majornak for the people, P84088.
And good morning, Your Honor. Good morning to your staff. Defender Services by Ken Riggins, P82125, on behalf of Mr. James Bailey, who appears via Zoom.
State your name for me, please, sir.
I believe he's muted.
He's muted. While we wait for somebody to unmute him, Mr. Riggins, how are we proceeding in this matter this morning?
Your Honor, it's my understanding from Madam Prosecutor that they would like to go forward with the preliminary examination. I will tell the court I have been in contact with the complaining witness in this matter, Ms. Brianna Kushner, several times. I thought she was actually going to be on Zoom this morning.
She is.
It's my understanding that she does not intend to go forward with the case, but the prosecution obviously can do as they wish with the matter.
Your Honor, that is accurate. I have also spoken with the complaining witness several times regarding this matter. As I informed Mr. Riggins in the breakout room, I am still waiting on some certified copies of medical records. I believe I have two. Well, I sent out about 3 subpoenas for certified copies for different medical providers that complaining witness visited in relation to the injuries sustained from the assault. Due to the injuries sustained, the extent of the injuries sustained from the assault, and the fact that this is defendants, this is a DV third in addition to a great bodily harm, and due to the extent of the alleged injuries to complaining witness, the people are intending to possibly proceed without complaining witness upon review of the certified copies of medical records. So I would ask that for an exam date sometime after December 30th, because that is the due date on the subpoenas.
The next available date would be January the 17th at 12:30, I do believe.
Thank you, Your Honor.
And since I already have the 12 o'clock matter on that date, that is fine. And Your Honor, I'd like to address bond.
Yes, Mr. Riggins.
Your Honor, we were here a week ago for this matter. Bond in this matter is currently set at $25,000, 10%. Your Honor, my client has no means to make that bond at this time. Your Honor, this is a somewhat unique case. As I previously said, it's my understanding from speaking with Ms. Kushner several times that she does not wish the case to move forward. She, in fact, wishes to resume her relationship with Mr. Bailey. And again, as I told her, that the case is the prosecutors to do with what they wish. We can't do anything about that. But as far as her being afraid of Mr. Bailey, I don't think she has any fear of Mr. Bailey. Mr. Bailey is without means to make the bond, but I don't think he is a threat. Mr. Kushner certainly doesn't feel that he's a threat to her. So we're respectfully asking for a personal bond in this matter and to lift the no contact order and make it a no assault of contact.
Ms. Mandernack.
Your Honor, in this case, I do not believe that a bond reduction is appropriate, especially not a no assault of contact bond reduction. In this case, although the complaining witness does not wish to move forward, and although complaining witness indicates that she is not afraid of Mr. Bailey, I believe that she does have good reason to be afraid of Mr. Bailey. The pictures in this case are particularly egregious, Your Honor. Complaining witness's face she sustains such injuries that, for lack of a better term, Your Honor, her face looks like a black and blue balloon. She has extensive bruises littered throughout her body, including her breasts and her back. I would be concerned for complaining witness's safety if the bond were to be reduced.
Am I allowed to speak here? I'm sorry, I don't know the
No,
law.
ma'am. No,
Thank you.
ma'am.
I'm gonna mute myself. Thank you, Thank you, Your Honor.
Ms. Mandernack.
I'm sorry, Your Honor.
Were you finished with what you were saying?
I was finished.
Mr. Riggins, was there anything else?
Your Honor, again, I think we have pictures, and while the pictures are not pleasant, I think we should listen to a complaining witness in this matter. If the complaining witness does not feel that she's in any danger, if the complaining witness feels that what happened may not have been an assault, I think, are we in a better position than she is to care for her own safety?
Mr. Riggins, is the question really limited to Ms. Kushner being in fear of Mr. Bailey, or does it include Mr. Bailey being a threat to public safety? When you review his criminal history, this is not his first assaultive crime. So unless the allegation is that the previous cases involve Ms. Kushner, it means that other people have been harmed by Mr. Bailey and his actions, and there's a public safety component to the argument. So that being the case.
Yeah, I recognize that he does have other DVs, but as it has been explained to me, the other DVs come from a relationship where his wife was cheating and he was attempting to get out the way. He pushed her and she took offense to him getting her out the way. I don't think we have anything like we have in this case in any of the prior DV cases.
Was there anything else, Ms. Mandernack?
No, Your Honor. Those other cases did involve a separate complaining witness. And I know the court is intelligent enough to understand that pushing somebody out of the way, even if you find them cheating on you, is an assault. And based on the extent of the injuries, the defendant's criminal history, I do not believe it is safe for neither the current complaining witness nor the community at large for defendant to be out or for the bond to be reduced.
Mr. Riggins, the court is going to deny your request to modify bond. We'll refer the matter for bond review to pretrial services. Was there anything else, Ms. Mandernack?
No, Your Honor.
Anything else, Mr. Riggins?
No, Your Honor, thank you.
Thank you. Mr. Bailey, your in-person preliminary examination is scheduled for January the 17th, 2024 at 12:30 p.m. here in courtroom number 1 at the 34th District Court. All of the terms and conditions of the bond remained in effect. That concludes this matter. Thank you. Marianne, I missed it. Did Mr. Chirikian go in with Mr. Mohammed yet?
Yes, ma'am.
You did? Thank you.
Judge, I went in with the defendant. I didn't go in with Mr. Mohammed.
Oh, I'll put you in there, sir.
Thank you.
Mary Ann, can you hear me?
Yes, I can.
Okay. Oh, I see your screen there now. Mr. Dennis Thick has not checked in from Wayne County yet, has he?
Mr. Who, I'm sorry?
Dennis Thick.
No, I don't believe so.
Okay, thank you. I'm gonna
Well,
mute myself. I'm doing an arraignment with Magistrate Henman. I'll just turn myself off.
okay, thanks.
Excuse me, Mary Ann, this is Mr. Noakes.
Hello again, sir.
Hi, has Mr. AJ Stovall checked in?
I do not see him. Let me check a breakout room. Hold on one second.
All right, thank you.
No, sir, I don't see him yet.
Okay.
Take a good
Mr. Noakes,
Mr.
your
Stovall is
client.
connecting, Mr. Noakes.
Yeah, that's what I was just gonna say.
Mr. Davis, were you ready with Mr. Campbell, or did you need to speak to the prosecutor?
I want to speak to the prosecutor. Morning.
Good morning.
Good morning, Judge. I'll put him in my breakout room.
Thank you, ma'am.
You're good. Babe, no, I need you to take her.
Tanya Grove. Tanya Grove.
Yes.
And then the other one is
Paul Newman.
Paul Newman.
Yes. Thank you.
You're welcome.
Mr. Noakes, you should see an invitation to join breakout room 11.
Mary Ann,
Yes, ma'am.
I need a date for a Sumter misdemeanor pretrial, please.
Okay.
This is 230721 SM and 230804 FY. These are both State of Michigan versus Stephen Campbell. May I have your appearances, please?
Good morning, Your Honor. Patricia Madernak for the people, P84088.
Good morning, Your Honor. Maurice Davis, P76203, appearing with Stephen Campbell, who's present, appearing via Zoom. Mr. Campbell, please state your name.
Yes, hi, Your Honor. My name is Stephen Campbell.
Mr. Campbell, would you turn your video on for me, please? Today is the day and time
Yes.
set for the adjourned pretrial and the adjourned PCCs in these matters. Mr. Davis, how are we proceeding?
Judge, we are prepared to waive the preliminary exam, have this matter bound over to circuit court.
Thank you. Mr. Campbell, raise your right hand for me, please, sir. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Thank you, sir. You may put your hand down. You've had the opportunity to speak to Mr. Davis, and you understand that you have an absolute right to have a preliminary examination. But the prosecution would have to show that probable cause exists to believe that a crime has been committed and that you were involved in the commission of that crime.
Yes.
And having had that conversation with Mr. Davis, you wish to waive your right to have that examination.
Yes, he said that would be the best option.
And sir, are you waiving this exam freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to waive this exam?
No.
Mr. Davis, because you appear by Zoom, there is not a signed waiver in the file. Do you authorize this court to sign the waiver on your behalf and on behalf of your client?
I do, Judge.
Any objection, Ms. Mandernack?
No, Your Honor.
Thank you. And same question to you, ma'am. Because there's not a signed waiver, do you authorize the court to sign the waiver on your behalf?
Yes, Your Honor.
Mr. Campbell, the court will find that your waiver of this preliminary examination has been freely and voluntarily given. With the permission given by Mr. Davis, the court is executing the waiver of that exam. The next step in these proceedings, sir, is that you will be bound over to the circuit court for arraignment on the information with the sole count in this matter of being an aggravated stalking. Your previously entered bond with any conditions will continue. Your arraignment on the information date will be December 20th, 2023 at 9 a.m. at the Frank Murphy Hall of Justice. And that's for the case that's 230804 FY. Mr. Davis, as for the state misdemeanor matter 230721 SM, how are we proceeding in that matter?
Judge, we can set it out 30, 45 days, just track along with the felony.
Set it out, adjourn it, or set it out, schedule it for trial?
Adjourn it, set it for another pretrial.
Absolutely.
January 10th, Judge, at 9 o'clock.
Is that sufficient time, Mr. Davis?
Yes.
January 10th, 2024 at 9 a.m. back here in number 1 by Zoom. Is there anything else in these matters, Ms. Mandernack?
No, Your Honor.
Anything else, Mr. Davis?
Nothing else, Judge. Thank you.
Thank you. Mr. Campbell, you're free to go. Good luck to you, sir. Have a good day.
Thank you, Your Honor.
This
Thank you.
is,
I will see you at 12:30.
yes, ma'am.
AP, sorry, AP Mandernack, can I speak with you 1 minute before you leave?
Can you give me a call?
Yeah, sorry, Your
Thank
Honor.
you.
You can send me your number in chat. I don't have that.
Yeah, I'll send you an email with it.
This is 230887 FY, State of Michigan versus AJ Stovall. Your appearances.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. AJ Stovall. Mr. Stovall, please tell the judge your name.
AJ Stovall.
Thank you, Mr. Stovall. Today is the day and time set for the adjourned PCC. Mr. Noakes, how are we proceeding?
Your Honor, we're requesting an in-person preliminary examination and a date therefore.
Is discovery complete in this matter, Mr. Noakes?
Your Honor, I believe I have all of the discovery. I was reviewing it yesterday, so I think we have it all. If not, I'll contact Ms. Johnson and make sure we do have it all.
Thank you. Mr. Noakes, before we schedule this matter for exam, I'd like to disclose on the record that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the issuing agency in this case. My husband's not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about Mr. Stovall's case. He doesn't even know that it's scheduled. That disclosure having been made, sir, would you like the opportunity to speak to your client, or are you prepared to proceed with the scheduling of the exam?
Your Honor, I'm prepared to go forward. It turns out
the exam will.
If it turns out there is a conflict, I will certainly let the court know.
Thank you, Mr. Noakes. That preliminary examination will be scheduled for January the 17th, 2024 at
1 o'clock.
At 1 p.m. It's live here in courtroom number 1 at the 34th District Court. Mr. Stovall, notice of that date, time, and location will be mailed to you at the address we have on file. Is there anything else in the felony matter, Mr. Noakes?
No.
Thank you. Mr. Stovall, you have another unrelated matter here with the court that's in warrant status. It's 23SU00634BOT. This is a driving while license suspended out of Sumter from June the 21st, 2023. Mr. Stovall?
Yes, ma'am.
The court is recalling the warrant that's currently in effect in this case. Having you stand mute to the charges. Setting your bond at $1,000 personal. Sir, you don't need to post any money, but what you must do is appear for pretrial in this case on January 11th, 2024 at 9:10 a.m. Marianne, who's Sumter then?
You are.
Oh, me. Mr. Stovall, you're back here with me on Zoom on January 11th at 9:10 a.m. for this driving while license suspended case. Notice will be mailed to you of that date for the misdemeanor case, okay?
Yes, ma'am.
Thank you. That concludes the matter.
Thank you, Your Honor. Mr. Stovall, please go ahead and text me your phone number so that we can talk.
Okay.
Thank you.
All right,
I'll
guys.
see you later.
Thank you.
Thank you, Your Honor.
Have a good day.
You're welcome, Mr. Noakes. Mr. Schulman, have you spoken to the prosecutor or do you need to?
I have spoken with the prosecutor. We're going to set this for a final pretrial conference.
This is 230782SM. This is State of Michigan versus Bradley Molly. May I have your appearances, please?
Richard Schulman on behalf of Bradley Molly.
Unmute yourself and state your name for me, please, sir.
Bradley Molly, Your Honor.
Thank you. Mr. Schulman, I don't show that your client has been arraigned. For purposes of arraignment, sir, how would you like to proceed?
My client stands mute and waives the formal reading of the information.
Thank you. Your bond, Mr. Malley, will be set at 5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. Your final pretrial date will be
January 3rd at 9 o'clock.
Thank you.
January 3rd, 2024 at 9 a.m.
Got it, Your
That
Honor.
will be on Zoom. I'm sorry.
Oh, yes, I have it, Your Honor. I thought you were speaking to me. Sorry.
You're okay. That will be by Zoom in number 3 with Judge Green. Was there anything else, Mr. Schulman?
No, Your Honor. Thank you very much.
Thank you. That concludes this matter. Notice will be mailed to you at the address the court has on file, sir.
Thank you, Your Honor.
Are we ready on Sarna?
I don't know where the attorney went, but I'm ready, Your Honor.
Ready, Your
We're
Honor.
not ready until at least, Ms. Medina, thank you.
Ready, Your
This
Honor.
is 230885 SM, State of Michigan versus Ryan Sarna. Your appearance, please.
Crystal Marie Medina, Your Honor, on behalf of Mr. Sarna. Mr. Sarna, would you please say your full name for the record, sir?
Ryan Patrick Sarna.
Thank you. Today is the time for the pretrial. Ms. Medina, how are we proceeding?
Your Honor, at this time, my understanding, although I haven't been able to download and confirm, is that I have been sent paper and digital discovery as of this morning. I did have the opportunity to speak with APA Mandernack, and we'd be asking to set this for a final pretrial, Your Honor. My client did inquire about visitation with his 2-month-old child in common, and APA Mandernack's position is that he should address that through the family court, Your Honor.
The final pretrial date will be
January 3rd at 9 o'clock.
January 3rd, 2024 at 9 a.m. That will be by Zoom in number 3 with Judge Green. Is there anything else, Ms. Medina?
No, Your Honor, and you said by Zoom. No. Thank you, Your Honor, by Zoom, Judge Green.
Thank you. Mr. Sarna, notice will be mailed to you at the address that the court has on record, January 3rd at 9 a.m. with Judge Green. Have a good day, sir.
Thank you as well.
Thank you. Ms. Segura, I see your name next to Chris Mira Jeffrey. Do you have something else that's ready this morning? Good morning. Are you looking to speak to Mr. Chirikian regarding the Durr matter?
Yes, yes.
Let's get you connected with him, sir.
Join.
Mary Ann?
Yes, Jeff?
I'm waiting for a Michael McDaniel. He's about a half an hour late. Has he appeared at all?
Not that I'm aware of.
All right. I also somehow lost my picture.
Yeah.
Madam Clerk,
Yes, ma'am.
I am here on Krishmira Jeffrey, and she indicated that she cannot log on today. So I was just gonna ask if I could waive her appearance. I already spoke with the prosecutor, so whenever the judge gets back, I'm ready to go on that matter.
She's here. The judge is back.
Okay,
Oh, I called your name, ma'am, and you didn't respond.
sorry, I was in Judge Blount's courtroom. I'm at Frank Murphy at the moment.
Understood. This is 230-701 FY, State of Michigan versus Jeffrey. Your appearance, please.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service on behalf of Miss Jeffrey, P86432. I spoke with Miss Jeffrey earlier and she indicated she was not able to log on this morning, so I would ask to waive her appearance as I have been in contact with her.
Just for clarification, not able to log on because?
You know, Your Honor, I did not inquire further and I apologize.
I'm just curious what's more important than the outstanding felony matter, but that's just my own curiosity, I guess.
Yeah, no, I understand, Your Honor.
You had the opportunity to speak to Mr. Mohammed this morning?
I spoke with Ms. Sobe, Your Honor, and I did speak with Mr. Mohammed about this case previously. At this moment, so we were here for a PCC, I believe last week, and I was asking for further discovery. I was missing the body cam footage as well as the dash cam footage on this arrest. I had asked for it. I did email the officer in charge who also emailed someone else in their department, and it is being uploaded as far as I'm aware, but I have not received that yet. In this case, I think it is really crucial to my argument potentially. So I would just ask for one more PCC just to ensure that I do get that before we schedule it for preliminary exam.
Thank you, ma'am. I'll make the notation that the digital discovery remains outstanding. We'll adjourn the PCC to
January 3rd at 9:15.
January 3rd, 2024 at 9:15 a.m. That will be by Zoom in number 3 with Judge Green. Anything else in this case, ma'am?
Nope, that's it. Thank you so much.
Thank you. These are 230-570 and 230-640. These are both State of Michigan versus Dennis Thick. May I have your appearance, please?
Good morning, ma'am. Dennis Thick here.
Thank you, Mr. Thick. I'm just waiting for Mr. Hadley to respond and put his appearance on.
How are you this morning, Your Honor?
I am super. How have you been?
Good, ma'am. Good. Getting better.
Good. Your appearance, Mr. Hadley?
Sorry about that, Your Honor. I'm hitting all the wrong buttons. Attorney Josh Hadley, on behalf of the defendant, Mr. Dennis.
Mr. Hadley, both of these cases were scheduled this morning for pretrial. Have you had the opportunity to speak to the prosecutor?
Your Honor, I have not spoken to the prosecutor on that. What we're going to be asking for is one more adjournment. I have spoken to Neighborhood Defender Services. Mr. Jonathan Cohen is representing Mr. Thick on this matter. There was a recent pretrial. It's our understanding that there's going to be a global plea resolution. 1 second, Your Honor. I'm sorry. Sorry about that, Your Honor. So I just want to make sure I understood Mr. Cohen's email. Yes, he's basically stating that there has been a plea offer put forward. It's not yet been accepted. They're still working on the full terms and conditions, but it's our belief that these pending misdemeanors will be included in that global plea resolution.
How long of an adjournment are you looking for, Mr. Hadley?
His next appearance date, Your Honor, and third circuit.
Is set for January 12th. I would just request that the matter be pushed out past the January 12th date.
17th or the 24th?
Let's do the 17th, Your Honor.
17th, January 17th, 2024 at
9 o'clock.
at 9 a.m. That will be by Zoom back here with me in number 1 in both matters. Is there anything else, Mr. Hadley?
No, Your Honor. Thank you for your time. Good luck, Mr. Thick. We'll be
Thank you.
talking very soon.
Thanks, sir. You have a good day.
Good morning, Judge.
Good morning. Give me 1 second.
No problem.
When my head is down and I'm writing, I can't see you. So when you call out like that, it doesn't matter.
Fair enough.
Are you calling out for Mr. Woolley?
Yes, I kept him
I
waiting.
was
'cause I
looking
had
for
to
you. You
step-
had disappeared for a minute there, Mr.
I
Martin.
know.
This is 230-888 FY, State of Michigan versus John Woolley. Your appearances, please.
I'm not hearing from the prosecutor, so I'll put my appearance on. Neighborhood Defender Service, Kerry Martin, P84592, appearing on behalf of Mr. John Woolley, who appears by Zoom. Mr. Woolley, state your full name.
John Wesley Woolley.
Thank you. Mr. Martin, how are we proceeding with this case this morning?
Your Honor, this case should be set for exam. I have it from Mr. Woolley that the complainant, his mother, does not wish to go forward. I would ask for dismissal today, but I don't believe any prosecutor has conferred with his mother, so I think just I have full discovery as well.
That live exam date will be January the 17th, 2024.
At 1:30, Judge.
Thank you. At 1:30 p.m., that will be here, Mr. Woolley, in person at the 34th District Court and courtroom number 1. Is there anything, case Mr. Martin?
Nothing further. Thank you, Judge. Mr. Woolley, I'll
Thank
get in
you.
touch with you soon.
Okay, thank you.
Take care.
Judge or clerk, what was the date for that Woolley PE?
January 17th at 1:30 p.m.
Thank you, Judge.
Mr. Kaplan, I was just gonna say, as soon as I get my files back, I'll call Ms. Grove's case, and Officer Garcia is walking in with them right now.
Thank you.
Sorry.
No worries. These are 23RP 05756 A and B. These are State of Michigan versus Grove. Your appearances, please.
Joshua Kaplan for the people, or excuse me, Joshua Kaplan for Miss Grove, Your Honor.
Your name for the record, ma'am?
Tania Grove.
Thank you. These cases are scheduled for arraignment, pretrial, and pre-hearing this morning. Mr. Kaplan, how are we proceeding?
We do have a resolution on this case where she would plead guilty to fail to report an accident and the responsible to the equipment violation with the dismissal of the leaving the scene of the accident, Your Honor.
Thank you. Ms. Grove, raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. May you put your hand down? Ma'am, you've had the opportunity to speak to Mr. Kaplan this morning, and you understand the charges you face and the possible penalties.
Yes.
And after having that conversation, is your understanding and agreement that you'll be tendering a plea of guilty to failing to report an accident and responsible to the defective or missing equipment civil infraction?
Yes, I do.
And ma'am, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
I do.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
I do.
And ma'am, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty and responsible?
No, I have not. Yes.
You're pleading guilty and responsible because you are in fact guilty and responsible?
Yes.
Ma'am, is it true that on October 30th, 2023, in the city of Romulus, you failed to report an accident?
Yes.
Ma'am, is it also true on that date and location that you had an equipment violation? You had a car without a working steering column?
Yes.
Satisfied, Mr. Kaplan?
Satisfied.
Ma'am, the court will accept your plea of guilty to failing to report an accident, dismiss the original charge, and responsible to the equipment violation. For the civil infraction equipment violation, the court will assess a fine of $195. For the failing to report an accident, the court will impose the following: a fine of $100, cost of $100, $75 mandatory crime victims fee, $50 mandatory state costs, and $20 fund fee. Ma'am, are you able to pay these amounts within the next 5 days?
Would I be able to do a payment plan?
Absolutely. Ma'am, what I'll ask you to do is either come into the courthouse and speak to the collections department, or you can go online to the court's website. There's a contact us button. You hit it, it'll drop down, and you can submit a request for a payment plan, or you can call and speak to the court's collection department. They will be able to make a single payment plan. You have another case for improper lights from Van Buren Township where you owe the court money. They can put all of your outstanding fines and costs into a single payment plan, okay?
Okay, perfect. Thank you, Your Honor.
Anything else, Mr. Kaplan?
Not at this time. Thank you, Your Honor.
Thank you. Ms. Grove, you're free to go. You have a good day.
You as well. Thank you both.
This is 230857 FY, State of Michigan versus Amari Durr. Your appearances, please.
Ryan Lukeski for the people, P73132.
Morning, once again, Your Honor. Samuel Chirikian appearing on behalf of Mr. Durr. My P number is 29888. Mr. Durr is present by way of Zoom from the Wayne County Jail.
State your name for me, please, sir.
Amir Durr.
Thank you. Today is the day and time set for the adjourned PCC. How are we proceeding this morning?
Well, Judge, we've had a chance to confer. Mr. Lukeski and I have discussed this matter. He's rather new to the case, Judge. He has been kind enough to indicate that he's going to supply me with the missing discovery in this matter. And we are going to talk about the case. We're going to seek resolution of the matter. And I wish to address bond. I've conferred with Mr. Lukeski regarding that as well.
And Your Honor, everything that's been uploaded to evidence.com has been shared, but I understand that was only 3 items. And so I didn't want to represent 2 specific items were shared if I didn't do it myself, which was a copy of the video of defendant making a statement, and then either a phone dump or a report of a phone dump of a number allegedly associated with Mr. Chirikian's client. So I can follow up with Detective Carmona this afternoon if that hasn't been uploaded, to either send that to Mr. Chirikian or facilitate, maybe get it on a flash drive. I know sometimes, especially with the phone information, that can be a large amount of data.
So, I'm sorry, Mr. Chirikian, I wasn't sure from your comments. Are you looking to adjourn the PCC or schedule for exam?
No, I think we can adjourn the PCC. I don't want to put witnesses out needlessly, but my client's been in the jail now for quite some time. This warrant was signed back in May, Judge, and my client got picked up. I still don't know what's going on with co-defendant Harris and there are other people listed in the investigator's report. I don't know if a warrant was even issued for those people or not. So we've got to do some legwork before we can set this matter for exam, Judge.
How long have an adjournment of the PCC, sir?
Well, Judge, I'm not available next Wednesday. I'm in Macomb Circuit that day. So it would have to be a couple of weeks at least, Judge, depending on what the court sees fit to do with regard to the bond. Then we would have some more flexibility.
The bond argument, sir?
Well, Judge, let me note that my client's current bond, according to my order of appointment, is $100,000 cash. My client is not charged in every count contained within the warrant here, Judge. He's only charged with 2 counts of receiving, concealing stolen property. I find that to be excessive, Your Honor. He's 22 years old. He resides with his mother. He's enrolled in GED classes. I'm going to suggest, and I've presented this to the prosecutor as well, I'm going to suggest the court consider house arrest, personal bond with a GPS tether.
Your response, sir?
Your Honor, defense counsel is right. There's 2 counts of RCSP over $20,000. What defense counsel left out is there seems to be involvement in what I would call a sophisticated ring around involving the airport, where license plates were stolen, cars were piggybacked. So even when the police reviewed the video and found the plates, they didn't come back to the correct vehicles they were registered. So it appears to be a somewhat sophisticated operation that the defendant is allegedly involved in. However, because he's only charged with 2 counts, for danger to the community, and to stop any possible involvement, it would be very beneficial to know exactly where Mr. Doerr is, if for his protection as well, because there could be allegations about this ring where we would want it would be helpful to know where Mr. Doerr was. So the people feel if bond is lowered that there should be house arrest with GPS tether, Your Honor.
Mr. Tarikian?
Well, Judge, I don't think he's a risk of flight, and if he's under house arrest, then I don't see how he's going to get involved in any other mischief. He's clearly not, based on what I see in the paper discovery, the brains of this operation, if you will. There are other people who certainly are more involved, including defendant number 1, who seems to be the mastermind based on what I see. I think that he was more of a mule as opposed to a leader. And I'd ask the court to impose a personal bond with tether and house arrest, Judge. As I noted, he does reside with his mother, Miss Jitana Milton, Jitana Milton. And I think she can be requested to be kind of the eyes and the ears of the court, in the sense that if he violates, she can immediately contact me and I will contact the court and the prosecutor.
Respectfully, Mr. Tarikian, the court is not inclined to go as low as a personal bond. It's reviewing the criminal history in this matter, and it appears that Mr. Doerr has found himself involved in other criminal activity regarding the receiving and concealing of stolen motor vehicles in other counties around the same time that this offense is alleged to have occurred. The court will reduce the cash portion to $25,000, 10%, with the requirement that if he posts, he remain on GPS tether for location purposes.
Well, we appreciate that, Judge. It's a step in the right direction.
And then adjourn the PCC out, I believe we were saying 3 weeks, which would put us on December the 27th at 8:30. Is that not a good date for you, sir?
Could we do 1 week beyond that, Judge, just after the new year?
Absolutely. January the 3rd, 2024 at 8:30 a.m. And that will be in number 3 on Zoom with Judge Green. Was there anything else on behalf of the people?
Not on behalf of the people. Thank you, Your Honor.
Thank you. Anything else on behalf of Mr. Durr?
No, Judge, I think we're all set. Appreciate it.
Thank you. That concludes this matter. Mr. Durr, your next appearance date is January 3rd, 8:30 a.m. Good luck to you, sir.
Thank you, Your Honor.
Mr. Kaplan, I'm just waiting for the officers to bring the files back in for your client, Mr. Newman.
I'm gonna let Jamie know he starts running for us, Your Honor. If you
Well,
could. He's getting slow on me.
Your Honor, we are ready on Mr. Wiggins whenever the court is ready.
I don't have the file, ma'am. As soon as it comes back, Newman and Wiggins were taken from me. As soon as they come back, I'll get the cases called.
Thank you.
You're welcome, ma'am.
Your Honor, this is Jeff Bowditch. I'm representing a gentleman, Mr. McDaniel, supposed to be here at 9:15. I believe he's failed to appear, Your Honor. I'm going to zoom off.
3S4250445 AST, State of Michigan versus Michael McDaniel. This case was in fact scheduled for 9:15. It's now 10:08 by the court's clock. Defendant having failed to appear. Matter will be set for show cause.
Thank you, Your Honor.
Thank you, Mr. Bowditch. Good morning, Mr. Cripps.
Good morning, Your Honor.
Are we ready with Mr. Martin?
The defense is ready.
Have you spoken to the prosecutor, sir?
No, I have not, Your Honor.
Sir, I sent you an invitation to join the breakout room.
Thank you, Judge.
Detective Carmona?
Yes, ma'am. Good morning.
Good morning. We've concluded that case. It's been adjourned over to January the 3rd of 2024 at 8:30 a.m. with Judge Green.
Thank you very much.
You're very welcome.
Have a good day.
Ms. Castro, I sent you an invitation to join the prosecutor's breakout room.
Oh.
Mary Ann, I'm stepping off for a moment, but if the attorneys come out, don't let them leave. I'll be right back.
Your Honor,
She will be right back.
thank you.
Sure.
I think that's my client, Clyde Martin, sitting in the Department of Corrections.
Do you need a breakout room with him?
No, I just need to get him arraigned.
Okay.
Judge, how are you?
What, are you bringing them back or you taking something?
I'm taking Garage Shield.
No, I was waiting for something back.
I'll bring them back. Which one you want?
Mr. Kaplan is ready on his cases. The ones you took, Newman and what was the other one? Wiggins.
You need Newman and Wiggins?
When Mohammed's done with them, yeah, that'd be great.
I'm done with
In the
them.
interim, this is 17, I'm sorry.
Oh, I'm done with those.
172106 FY State of Michigan versus Clyde Martin.
Good morning, Your Honor. David Cripps, P 349702, appearing on behalf of Clyde Martin, who's joined us by Zoom from the Department of Corrections.
Morning, Judge.
Mr. Martin, would you state your name for me, please, sir?
Clyde Martin.
Thank you, Mr. Martin. Today is the day and time scheduled for the arraignment in PCC in this matter. Mr. Cripps, how are we proceeding?
My client would stand mute, waive the formal reading of the complaint warrant.
Thank you.
Can I give the mirror?
Sure.
Yeah, thank you.
Thank you. Mr. Cripps, the bond recommendation was from 2017 for 25,000, 10%. Your comment as to bond in this matter?
Judge, the bond is not really an issue. He's currently serving a sentence, so he won't be able to
Understood,
get it.
sir. You've had the
So I-
opportunity to speak to Mr. Mohammed for purposes of PCC.
No, I haven't, Judge. I'm just requesting that it be set down for a PCC. I see this case as we're going to try to resolve it as quickly as possible.
Thank you. Bond in this matter is set at 5,000 personal. The PCC, Mr. Cripps, 1 week, 2 weeks, or 3 weeks?
2 weeks, Your Honor, would be fine.
2 weeks will put us on December the 20th, 2023 at 8:30 a.m. That will be by Zoom in number 2 with Chief Judge Brian Oakley. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge.
Anything else, Mr. Cripps?
No, Judge, thank you very much. I appreciate it. It's good to see you today.
Good to see you. Mr. Martin, that concludes this matter, sir. You're free to go.
Mr.
All right,
Chris,
thanks.
move you to a breakout room for a brief moment, just so I can exchange numbers in regard to resolving this.
Sure.
Two one WM 00142 CST, State of Michigan versus Alan Wiggins.
Crystal Marie Medina, Your Honor, on behalf of Mr. Wiggins. Mr. Wiggins, would you please unmute and say your full name for the record, sir?
Good morning.
State your name, please, sir.
Oh, Alan Wiggins.
Thank you. Ms. Medina, this case is currently in warrant status. The court will recall the warrant. And for purposes of arraignment, ma'am, what say you?
Your Honor, we would waive formal reading and stand mute as to the arraignment. I was able to speak to APA Mohammed, and the offers for an improper plate civil infraction that my client should pay within 2 weeks, Your Honor.
Mr. Wiggins, you've had the opportunity to discuss this case with Ms. Medina. You understand the charges you face and the possible penalties.
Yes, ma'am.
And after having that conversation, sir, is your understanding that you'll be pleading responsible to the added count of improper plates and the original charge of misdemeanor would be dismissed?
Ooh, awesome. Yes, ma'am.
I'm sorry?
Yes, ma'am.
That's how you like to proceed, sir?
Yep.
Yes?
Oh, yes. Yep. Yep. Mhm.
Thank you. The court will accept your plea of responsible to the improper plates and dismiss the misdemeanor plate violation. Court will assess a fine of $180. And Ms. Medina indicated 14 days to pay. Is that correct, Mr. Wiggins?
Yes, ma'am.
Ms. Medina, anything else?
No, Your Honor. Thank you very much.
Thank you. Mr. Wiggins, that concludes this matter, sir. You're free to go. You have a good day.
Oh, thank you. You too.
Thank you.
Hello.
Take your cap off, sir. State your name for the record.
Connor Holmes Jr.
Sir, you might see something pop up on your screen to go into a breakout room. Please go there. Mr. Kaplan, do you have something ready other than Mr. Newman, whose file I still don't have back?
No, just Newman's gonna be an adjournment, and then I have Kami Thompson at 10:45. That's a final pretrial victim to appear, so I figure that'll go till probably 11. Unless they appear.
Well, let's get Mr. Newman on his way. You've already spoken to the prosecutor, so we are. This is 3S4267462 ST, State of Michigan versus Paul Newman. Your appearances, please.
Joshua Kaplan on behalf of Mr. Newman, Your Honor.
Hello.
State your name for me, please, sir.
Mr. Newman, you there?
He's muted.
I'll call you back. I'm busy now.
Mr. Newman, can you say your name for the record?
Sure. Paul Newman.
And Your Honor.
Thank you. Today's the day and time set for the arraignment and pretrial. I'm sorry, Mr. Kaplan, go ahead.
No, I apologize. So we're just asking for like a 60-day adjournment. The reason for that adjournment is that he has applied for this hazmat specialty to endorsement, and he's in the process. It's just a matter of time. So we're hoping he could have it within 60 days, and the people are considering a dismissal once he gets it.
Are we adjourning the arraignment as well?
We can stay on mute to the chart, stay on mute, if you want, and waive arraignment or waive formal reading on that.
Thank you. Mr. Newman, the court sets your bond at 1,000 personal. You don't need to post any money, but what you must do is continue to appear as directed by the court until this matter is resolved in its entirety. The pretrial in this matter will be adjourned. 1, 2, 3. You said 2 months, Mr. Kaplan?
Yes, if that's possible.
That's possible. February 7th, 2024 at
9 o'clock.
at 9 a.m. That will be by Zoom in number 3 with Judge Green. Mr. Newman, notice will be mailed to you at the address that's on file with the court already, okay?
That's fine.
That concludes this matter, Mr. Newman. You're free to go. You have a good day.
Thank you, Your Honor.
You're welcome, sir.
Thank you, Your Honor. I'm just gonna wait on Mr. Kami Thompson to come on in, and so we can hopefully resolve that matter today.
Ms. Medina, are you ready with something?
Your Honor, I spoke to Derek Mitchell. It's an arraignment pre-trial. APA Mohammed seems to be pretty backlogged. We're just going to be seeking an adjournment of the pre-trial for compliance with license. So I don't know if the court is comfortable calling that one for the arraignment and just an adjournment of the pre-trial. I did not speak with APA Mohammed yet.
Mr. Mitchell? Mr. Mitchell, unmute yourself and turn your video on, please. These are 23 BL 00557 B and C. These are State of Michigan versus Derek Mitchell.
Crystal Marie Medina, Your Honor, on behalf of Derek Mitchell, with regard to the arraignment, we would waive formal reading and stand mute, Your Honor.
State your name, please.
Derek Mitchell.
Thank you. Both of these cases, Ms. Medina, are currently in warrant status. The court will recall the warrant. I heard your indication regarding waiving the reading and standing mute.
Thank you, Your Honor.
Court will set bond in this matter, in these matters at 3,000 personal. You do not need to post any money, but what you must do is continue to appear as directed until this matter is resolved in its entirety.
Yes, ma'am.
And we'll adjourn the pre-trials out to, let's say 2 weeks, Marianne.
December 20th at 9 o'clock.
Your Honor, is there any way that we could have a date in the middle of January? She's trying to accomplish some things with regards to paying off some tickets and getting things in order, Your Honor. I don't think 2 weeks will put us in the same place.
Absolutely. We'll adjourn it over to this court's next criminal docket, January 10th, 2024 at
9 o'clock.
At 9 a.m. That's on Zoom back here with me in number 1.
Thank you, Your Honor.
Was there anything else, Ms. Medina?
No, Your Honor, thank you.
Thank you. Before you leave, just a reminder, there's another outstanding case, 23BL000981OT, false information to police where you have failed to appear. Contact the court. That case is being set for show cause for your failure to appear previously, okay?
Okay. Could I add a few things to that?
Not about that case because I don't have it. I don't have the actual file. I
Okay.
just have a note that you have a case where you have failed to appear and they'll be setting it for show cause. I just don't
Okay,
want you
yeah.
to lose track of it, okay?
Thank you.
Thank you. That concludes
you,
this
Your
matter.
Honor.
You're free to go. I'll see you in January.
Okay, thank you.
You're welcome.
Why is my case taking so fucking long?
You have yourself, ma'am.
No, let's have profanity in courtroom. Why not? Mr. Mohammed, what are you ready with, sir?
Both of Miss Nicole James' cases. I believe it's Isaiah Grantham and Michael Angel, which will be a waiver.
Correct.
This is 230780FY. This is State of Michigan versus Isaiah Grantham. Your appearances, please.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Grantham. My P number is 58961.
Mr. Grantham.
Hi, Miss Isaiah Daniel Grantham.
Thank you. Today's the day and time set for the PCC in this matter. Ms. James, how are we proceeding?
Judge, we would like to set this for preliminary examination.
Ma'am, is discovery complete?
I believe so. I have the paper and I have a digital file.
Thank you. The live exam will be scheduled for January the 17th, 2024 at, are we at 2 o'clock, Mary Ann?
Yes, we are.
Thank you. At 2 p.m. Mr. Grantham, January 17th, 2024 at 2 p.m. in person in courtroom number 1 at the 34th District Court. Is there anything else in this case, Mr. Mohammed?
Nothing from the people.
Anything else, Ms. James?
No,
You're
Honor.
welcome. Mr. Grantham, you're free to go. You have a good day, sir. And Ms. James, I missed the name of your other client.
Michael Angel.
This is 230456FY, State of Michigan versus Michael Angel. Your appearances, please.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Angel. My P number is 58961.
Mr. Angel,
Yes, Your Honor.
your name for the record, please.
Michael Allen Angel.
Thank you. Today's the day and time set for the PCC. Ms. James, how are we proceeding?
Your Honor, I've spoken to Mr. Angel about his right to have a preliminary examination and what the people must show. He wishes to waive his preliminary examination.
Thank you. Mr. Angel, raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down. You've had the opportunity to speak to Ms. James, and she advised you that the preliminary examination will be where the prosecution will have to show that a crime had been committed and that probable cause exists to believe that you were involved in the commission of that crime. That's the question, sir. I'm sorry.
Oh, yes, Your Honor.
And after having that conversation with Ms. James, you wish to waive your right to have that preliminary examination.
Yes, Your Honor.
And sir, you're doing so freely and voluntarily?
Yes, Your Honor.
You haven't been threatened in any way or promised anything to get you to waive the exam?
No, Your Honor.
Ms. James, because you appear by Zoom, there's not a signed waiver in the file. Do you authorize the court to execute the waiver on your behalf and on behalf of your client?
I do, Your Honor.
Mr. Mohammed, do the people have any objection to this waiver?
No objection, Judge.
And any objection to the court signing the waiver on behalf of your officer?
No objection.
The court finding that Mr. Angel's waiver of the exam has been freely and voluntarily given, the waiver being executed. Mr. Angel, you'll be bound over as charged to Circuit Court. Your next appearance date will be an arraignment on the information on December 20th, 2023 at 9 a.m. at the Frank Murphy Hall of Justice. Your previously entered bond with any of its conditions will continue. Is there anything else in this matter on behalf of the people, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Ms. James?
No, Your Honor. Thank you.
Thank you. That concludes this matter. Mr. Angel, you're free to go. You have a wonderful day.
Have a good one.
This is 230718FY, State of Michigan versus Sierra Lattimore. Your appearances, please.
Good morning, Your Honor. May I please the court, Austin Gregory, PA 5193, on behalf of Ms. Lattimore, who's present by Zoom. Ms. Lattimore, please unmute and state your name for the record.
Sierra Lattimore.
Thank you. Today is the day and time set for the PCC. Mr. Gregory, how are we proceeding?
Your Honor, we have received discovery in this matter, or at least paper discovery as well as video. We will be asking for a live in-person exam.
Mr. Gregory, before the court schedules that exam, I want to disclose to you on the record that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the issuing agency of this case. My husband is not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about Ms. Lattimore's case. He doesn't even know that that case is scheduled for hearing today. Do you need a moment to speak with your client, or are you prepared to proceed with the scheduling of the exam?
Your Honor, briefly, Ms. Lattimore, do you need to speak with me about this?
Not that I believe so. I don't really know.
Okay, thank you. No, we do not need to speak, and we do wish to proceed with the exam.
Thank you. That exam date will be
January 17th at 2:30.
January 17th, 2024 at 2:30 p.m. That's live in courtroom number 1 at the 34th District Court. Notice of that date and time will be mailed to Ms. Lattimore at the address that we have on file. Is there anything else in this case, Mr. Gregory?
Nothing further, Your Honor.
Thank you. Ms. Lattimore, you're free to go. I'll see you at that date and time.
Thank you.
You're welcome. This is 23 HR 10909A, State of Michigan versus Jacob Saunders. May I have your appearance, please? You're muted, ma'am.
I'm sorry about that. Hi, my name is Bernadette Castro. I'm the attorney that represents Mr. Jacob Saunders, P number 70997. My client is present via Zoom.
State your name for me, please, sir.
Jacob Allen Saunders.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter, ma'am. How would you like to proceed?
Your Honor, my client would like to waive the arraignment and put in an entry of not guilty for this hearing.
Thank you. Have you had the opportunity to speak to Mr. Muhammad this morning?
Your Honor, my client is Mr. Saunders. Oh, Mr. Muhammad, I apologize. No, I have not this morning. I'm sorry, Your Honor.
That's okay.
I sent you an invitation to speak with him, ma'am.
Oh, I see. Okay. I'm having a hard time with this, Your Honor. I just had to go from my computer to my phone. I can go ahead and
I was gonna say, Ms. Castro, what we can do is set your client's bond. 5,000 personal. Mr. Saunders, you don't need to post any money, but what you must do is continue to appear as directed by this court until this case is resolved in its entirety. Ms. Castro, if you want to go in and speak to Mr. Muhammad, we can do that. Otherwise, we'll be scheduling the pretrial date probably 2 or 3 weeks down the line.
If I could speak to Mr. Muhammad, I will be requesting additional discovery, so yes.
Okay, thank you. We'll get you in with him.
Thank you very much, Your Honor.
You're welcome.
Ma'am, you should see an invitation to join his breakout room.
I'm not. 1 second here. I'm not getting. Whoops! I just saw it and I just flipped it off. 1 second. For a second, I don't know. I'm having such a hard time. I apologize.
I've tried to navigate on the phone as well, Ms. Castro. I know it's difficult.
Thank you for your patience.
Good morning, sir. How are you?
Freezing.
Freezing. Yeah, it's cold in here.
The heat went on at 10 o'clock.
Why?
Well, it's on, I think it's on timer. People.
Mr. Lundberg, you reached an agreement with Mr. Mohammed for your client to plead responsible to impeding with 2 weeks to pay.
Correct, Your Honor.
Court will accept. Go ahead, sir.
Mr. Singh is here, but that's the agreement I reached. Yes.
I'm sorry, I didn't hear what you said.
Mr. Singh is here as well, but the agreement that you have.
Thank you.
Is proper. Yes.
Court will accept the plea of responsible. Impose fines of $195 with 14 days to pay. Was there anything else, Mr. Lundberg?
Nothing further. Thank you, Your Honor.
Thank you. Have a good day, sir.
Yep.
Mr. Martin, thank you.
Hello, I'm back on Ms. Japenga.
This is 220555 FY State of Michigan versus Japanga. Your appearances, please.
Not hearing from the prosecutor, I'll go ahead. This is Neighborhood Defender Service, Carrie Martin, P 84592, appearing on behalf of Ms. Michelle Japenga. We appear by Zoom. Ms. Japenga, state your.
Michelle Japenga.
Thank you. Mr. Martin, the court received an order regarding discovery.
Yes.
But it was setting discovery due a day after the order was received and the 2 days before this PCC.
Yes, I had submitted that last week, I believe. I believe it was last Wednesday. And I never got a signature on it. However, I would like to address it today because I still have not received digital discovery in this case. I don't know if the prosecutor is present right now, but perhaps you could orally issue a discovery order with a deadline in advance of an exam date or a deadline in advance of a next PCC date. I do believe digital discovery is necessary in this case for it to proceed.
Mr. Martin, the order wasn't signed again because when it was presented to me was on Monday the 4th, setting a deadline of December the 5th. And because there were no notes indicating that the discovery had been at issue at the last PC, I didn't want to sign it. I knew I would see you today. I'm happy to sign it today. You tell me how long.
Thank you. Perhaps we could just set another PCC out 1 week and you could set a deadline of the end of this week or 1 or 2 days before the next PCC and see if the prosecutors are able to dig up that discovery.
Thank you. Mr. Martin, the court is signing the order for supplemental discovery that was previously presented to the court, setting the deadline to turn those digital discovery over to the defense of December 12th.
December 12th.
And we'll adjourn the PCC to December the 13th at
9:30.
At 9:30 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley.
Very well. Next week with Judge Oakley. What was that time?
9:30, Mr. Martin.
9:30. Thank you very much.
Anything else?
Nothing.
Thank you. Ma'am, you're free to go. You have a good day. Good luck to you.
I'll get in touch with you, Mr. Penga. And I'll see you later, Judge.
Yes, sir. To the people that are here waiting, I see you. I know that you're here. I appreciate your patience. Your attorney is waiting to speak to the prosecutor, or we are waiting for your attorney to arrive, one or the other. But as soon as your attorneys pop out, I will get your cases called and get you on with your days as soon as possible.
Thank you.
Good morning, Mr. Upshaw.
Good morning, Your Honor.
This is 230877 SM, State of Michigan versus Trenton Newby.
Hello, how you doing, Your Honor?
And for the record, Your Honor, Randall Upshaw, P number 43574, on behalf of Mr. Newby.
Thank you. Mr. Newby, state your name for the record, sir.
Trenton Newby.
Thank you. Today's the day and time set for the pretrial. Mr. Upshaw, you've had the opportunity to speak to the prosecutor. How are we proceeding?
Your Honor, the prosecutor and I both agree we will set a final pretrial conference, making it mandatory for the victim to show up at that hearing, and we should resolve it on that day one way or the next.
Thank you. That final pretrial date will be
December 13th. Is that enough time?
That's fine, Your Honor.
At 9:45.
December 13th, 9:45. I'll see you then. Thank you.
And that will be, Mr. Upshaw, that will be in number 2 with Chief Judge Brian Oakley, which makes it an in-person final pretrial, sir.
Oh, that's horrible. But we have to be there. Let me double check. Hold on, please.
Mr. Muhammad, are you, is there something else you have ready, or do you need to go back in with the other defense attorneys?
I'm gonna go back, but I did have a quick question in regards to subpoenas for final pretrials at this court. Does it come from the court or is it something we do?
Something you do.
Okay, just wanted to make sure.
I
Thank
have
you.
one question. That date is pretty bad for an in-person. Could I have any other date? Or I'm available in the afternoon.
Mr. Upshaw, we can do it any Wednesday, but you may also submit a request to Judge Oakley to appear by Zoom. You tell me, Judge Oakley, with the request to his court to appear by Zoom or a different date. The next date for Zoom will be December 27th.
December 27th. I'll take, I'm not sure. I'll 27th. That's horrible. I'll make it and I'll submit a request on the 13th to Judge Oakley. Thank you.
The 13th at 9:45 with Judge Oakley. Submit a request to his chambers. Anything else, Mr. Muhammad, in this case?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Upshaw?
No, Your Honor. Thank you very much for your patience.
You're very welcome. Mr. Newby, you're free to go. You have a good day, sir.
You as well. Thank you.
Thank you. Mr. Kaplan?
Yes, Your Honor.
No. Ms. Thompson's at 10:45.
Yep.
Are you covering for Mr. Nonley by chance?
I can if the court needs me to on something, but no.
No, I don't. I saw him earlier. Wait, he might be in. Nope, he's in the waiting room. I see him. I need to get Mr. Haysha back out here for Ms. McGrath and then Mr. Duggan, Mr. Dubin.
All right, I will. I'll come back at 11.
No, I'm not, Mr. Kaplan. I'm talking out loud to myself. I'm sorry.
Judge, do you want
I'm
me to
just
pull
watching
those,
people wait.
do you want me to pull them out, Judge? The two attorneys you just,
I don't want to interrupt their conversations
Okay.
with the prosecutor, but Ms. McGrath has been here, Mr. Clark, Ms. Meadows, Ms. Redding. It's but you know, I'm always convinced that if I get up and walk away, then everybody will come out and be ready at the same time.
Yeah.
Would you grab the Paul Newman file, please, from the prosecutor for me? Newman, thank you. Bye. thank you.
But the other ones too, I'll get them.
No, not until he's ready with them. I just,
Okay.
this case, that case has already been called.
Is there this because he looks to being adjourned? I says, I don't know.
Yes, we called it already.
Okay.
Nope. Are you overriding the system? Ken just told me that it went off at 10 o'clock. Well, I dressed accordingly because it's been.
And out here, we got to turn that out. This whole section is full.
Oh. Mr. Clark is giving the international sign.
I'm sorry.
No, Mr. Clark, I understand completely, trust me.
Your Honor, I was just checking in if I should bring in Miss Thompson into the courtroom by any chance.
That was wonderful how you asked it, Mr. Kaplan. Of course, bring your client in, please.
Thank you.
I'm not sure if Dana So is able to stand in this matter.
I can ask Mohammed. Just give me one moment, Your Honor. For
Thank
which
you.
defendant is this?
It's Cammie Thompson. It's a final pretrial scheduled at 10:45 with the order that the complainant appear.
Okay, one moment, Your Honor. I'll be back.
Thank you. Mr. Dubin, do you need to speak to any of your clients?
I do not, Your Honor. I am ready to go on all.
Thank you. Mr. Kaplan, if you sit tight, I'll circle right back to you. This is 230770 SD. This is State of Michigan versus Timothy Kanawalski. Your appearances, please.
Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Konowalski.
Unmute yourself and state your name for me, please, sir.
Do you hear me?
Yes, sir. State your name for me.
Timothy Konowalski, Timothy Lee Konowalski.
Thank you. Today's the day and time set for the pretrial. Mr. Dubin, how are we proceeding?
Your Honor, I forgot to mention standing in for Steve Mamet, but that's fine. I'm asking to set this for a motion hearing date for a motion to suppress, Your Honor.
How long will it take you to get your motion filed, sir?
Can we do 4 weeks, Your Honor? Or is that too long?
4 weeks. I'm sorry, you said you were did you say you were standing in for somebody?
Yes, Mr. Mamet. We're same office. Or is it, if it's me as the attorney of record, it's perfectly fine. We do like together. So
4 weeks puts you on January 3rd with Judge Green.
okay. Is that okay with the court? I don't want to hold the court up or anything like that.
It's your case, sir.
Okay.
January 3rd, 2024 at
Give me 1 second. I'm looking to see if she has an 11 o'clock open.
Yes, ma'am.
(10:30), Judge.
At 10:30 a.m. on Zoom in number 3 with Judge Green. I made a note in the file that you'll be filing a motion to suppress.
Yes, Your Honor.
Anything else, Mr. Mohammed?
Nothing from the people.
Anything else on behalf of the defendant?
No, Your Honor. Thank you so much.
Thank you. Sir, your case will be adjourned to January 3rd. Notice will be mailed to you at the address that you verified with court staff. You have a good day, okay?
You too, Your Honor.
Thank you. This is 230811 FY, State of Michigan versus Lisa Meadows. Your appearances.
Good morning, Your
Good,
Honor. Mohammed on behalf of the people, P-86771.
good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Ms. Meadows, who appears via Zoom.
State your name for me, please, ma'am.
Lisa Meadows. Lisa
Thank you.
Meadows.
Today is the day and time set for the adjourned PCC. How are we proceeding, sir?
Your Honor, we're asking for one more adjournment. I have spoken with the prosecutor. He is going to further review the discovery, and we do have a potential plea offer in place. So one more adjournment should be good.
How long of an adjournment are you looking for, sir?
I would refer to Mr. Mohammed. How long you think you need?
2 weeks would be good, Judge.
That's fine for me too.
2 weeks puts us on December 20th, 2023 at
9:15.
at 9:15 a.m. That will be in person in courtroom number 2 with Chief Judge Brian Oakley. Is there anything else in this case on behalf of the people?
Nothing from the people, Judge. Thank you.
Anything else on
Nothing,
behalf of the defense?
nothing from the defense, Your Honor. Thank you so much.
Thank you, Ms. Meadows. You're free to go. Notice that the new date will be sent to you at the address you verified with court staff.
All right, thanks.
This is 230781 FD, State of Michigan versus Harmony Redding. Your appearance, please.
Good morning, Your Honor. Mohammed on behalf of the people, P-86771.
Good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Ms. Redding, who appears via Zoom.
State your name for me, please, ma'am.
Harmony Redding.
Thank you. Today is the day and time set for the PCC in this matter. Mr. Dubin, how are we proceeding this morning?
Your Honor, we would ask just for an adjournment for a deviation.
How long of an adjournment are you looking for, sir?
3 weeks should be sufficient, Your Honor.
We'll put it over to December the 3 weeks puts us on December the 27th.
9 o'clock, Judge.
At 9 a.m. And that will be by Zoom in number 3 with Judge Green. Sir, before you return with your client, you might want to have a conversation with her about using Zoom. In your absence, she was unmuted using profanity on this court's record.
I will indeed, Your Honher. So I apologize on her behalf.
And I
No
apologize
apologies
too.
needed. I know
didn't
that some people just aren't used to working Zoom. It's fine. Just a little etiquette lesson might be helpful.
No problem.
Anything else, Mr. Mohammed?
Nothing from the people. Thank you.
Anything else on behalf of Ms. Redding?
No, Your Honor.
Thank you, ma'am. You're free to go. Your next court date is December 27th. Have a good day. Good luck to you.
Thank you.
This is 230862 SM, State of Michigan versus Cammie Thompson. Your appearances, please.
Good morning, Your Honor. Mohammed on behalf of the people, P-86771.
And Your Honor, Joshua Kaplan on behalf of Ms. Cammie Thompson, Ms. Thompson, Ms. Thompson, we say your name for the record.
Cammie Thompson.
Today was the day and time set for the final pretrial in this matter where the complainant was required to appear. Case was scheduled at 10:45. It's now 11:11 by this court's clock. Have we seen Todd John Daniels Jr.?
I did not see him, Your Honor. I apologize.
I haven't seen him, but if I can just look in the waiting room real quick.
Absolutely, sir.
Thank you.
Your Honor, I had another ticket as well.
That case was Mr. Dubin at what time?
It was Stoddard. I was just asking for an adjournment for that one too, just to talk with my client. The offer had been presented by Mr. Mohammed. I know he's busy, so I don't need him in here if the court's okay with it. A 1 week adjournment would be fine.
You said 1 week?
Yeah, it's fine. I just need to get a hold of my client just to present them the offer.
Marianne, is there space available on the 13th by chance?
Yes, at 10 o'clock.
Anything works, Your Honor.
These are 3S4299284 A and B. Jonathan Stoddard, they'll be adjourned over to December 13th at 10 a.m. that's in person with Judge Oakley in courtroom number 2. Sir, will you come back into the main session? If you shout out like that, people think it's okay, but if you wait patiently, I'll circle back to you, okay?
I apologize greatly. I'm so sorry. My phone actually turned off on mute and I thought I was still on, so I'm so sorry. I'm a little bit of a mess today, Your Honor. I apologize.
That's okay. That concludes this matter. You're free to go. Have a good day.
Have a good day, everyone.
Mr. Mohammed, any luck with your complainant, sir?
Yes, Judge, I spoke with the victim advocate and she let me know that she made 2 phone call attempts to reach the victim and was unable to reach that person in regards to
Your
this final
motion, Mr.
pretrial.
Kaplan.
Motion to dismiss, Your Honor, as a final pretrial with the victim to appear.
Defense motion to dismiss is granted. That dismissal is without prejudice. Anything else, Mr. Mohammed?
Nothing from the people.
Anything else, Mr. Kaplan?
No, Your Honor, just wishing the court a wonderful holiday. Mohammed, make sure to call me Josh, not Mr. Kaplan. The formalities. But you guys all have a wonderful holiday. It's a pleasure to be with you all today.
See you,
Thank you. Ms. Thompson, that concludes this matter. You're free to go. Mr. Mohammed, if you could take up Mr. Clark's attorney, SADRNIA up next, or Mr. Haysha.
Okay.
Thank you. Ms. Thompson, you're free to go, ma'am. Your case has been dismissed.
I know, I'm trying.
Oh, that's fine. We'll put you out. Don't worry. Thank you, Heather. Have a good day. January 17th. Yeah. Thanks. 230665 FY, State of Michigan versus Aiden Clark. Your appearances, please.
Good morning, Your Honor. Mohammed on behalf of the people, P 86771.
Good morning, Your Honor. May it please the court, Parisa Sadrina on behalf of Aiden Clark, who is present on Zoom and consents to proceeding via Zoom this morning. Aiden, please state your first and last name for the record.
Aiden Clark.
Today is the day and time set for the PCC. How are we proceeding in this matter?
Yes, Your Honor. At this time, we'll be asking for an exam.
Is discovery complete, ma'am?
Yes, Your Honor.
That exam date will be February the 21st.
May I have one moment, Your Honor?
Yes, ma'am.
Thank you. Would that
Mary
be
Ann, is that right? I'm sorry.
No, go
Yes,
ahead.
yes, it is at noon.
That's not a good date for you, ma'am?
No, I'm sorry, Your Honor. Was it February 21st at noon? Is that what you said?
Yes, ma'am.
That works fine. Thank you.
February the 21st, 2024 at 12 p.m. here at 34th District Court in courtroom number 1. Anything else on behalf of the people?
Nothing from the people, Judge.
Anything else on behalf of the defendant?
Nothing further, Your Honor.
Thank you. Mr. Clark, thank you for your extreme patience this morning, sir. I'll see
Thank
you
you
on
so
February
much.
21st at noon.
Thank you, Your Honor. Have a great day.
You too. Thank you.
Okay, bye.
Thank you, Your Honor. Have a good day to you and your staff.
Thank you, ma'am. You too. Mr. Haysha with Ms. McGrath. Mr. Mohammed?
Yeah, we're just, Tiana Lewis, we're ready. I'm just waiting for defense counsel.
Tiana Lewis?
Yes. It's a pretrial. I can come back. Maybe he's talking to her still.
Thank you.
Yeah.
This is 230817 SD, State of Michigan versus Tiana Lewis. Your appearances, please.
Good morning, Your Honor. Royce Nunley appearing on behalf of the defendant. Ms. Lewis, could you please state your name for the record? I don't even see her.
I see her. Let's get her. Oh, no. What happened? She was just here, Mr. Nunley.
I was just talking to her.
If you don't mind, Mr. Nunley, I'll pass her for one moment.
She said that she does.
Are you
have
ready
to-
on some of your other case? I'm sorry.
She said she did have to be to work at noon. I spoke with Mr. Mohammed about a resolution, and we agreed to just adjourn it one last time so he could look into something. So I see her connecting now. I just don't want to keep her up for work. We're just asking.
No, I understand. Ms. Lewis, unmute yourself. State your name for the record, please.
Tiana Lewis.
We're adjourning over how long, Mr. Nunley?
At the court's discretion. I don't think we need very long at all. He just needs to double check something with his higher ups, apparently.
Will 2 weeks be sufficient?
Yes, it will.
December 20th, 2023 at
9:30.
9:30. That's in person in courtroom number 2 with Chief Judge Brian Oakley. Is there anything else, Mr. Nunley?
There's not an available Zoom date with my favorite judge in the building, Judge Martin, is there?
Judge Green's actually available on the 27th.
Let me see. I think that might work.
If you
Yeah.
want
my
to submit the
counsel-
request to
that's
Judge.
Perfect. Yep, I have.
The
I'm house
27th?
counsel that day. That would be great.
27th at what time?
9:15.
At 9:15. Ms. Lewis, your case is adjourned to December the 27th at 9:15 a.m. That will be on Zoom with Judge Green. Notice will be mailed to you at the address that we have on file, okay?
Thank you, Your Honor.
Thank you, ma'am. Have a good day.
Thank you,
This
Judge.
is 230835 FY, State of Michigan versus Lisa McGrath. Your appearance, please, sir.
Judge Vincent Hayes appearing with and on behalf of Ms. McGrath, who's present via Zoom.
State your name for me, please, ma'am.
Good morning, Your Honor. Lisa Ann McGrath.
Thank you, Mr. Hacia. Today's the day and time set for the PCC. How are we proceeding?
Judge, I need a little bit more time on this. Can we adjourn this for 3 to 4 weeks?
Absolutely, sir. 4 weeks puts us on January the 3rd, 2024 at
9:30.
at 9:30 a.m. That will be by Zoom in number 3 with Judge Green. Was there anything else, Mr. Hacia?
No, Your Honor.
Thank you. Ms. McGrath, thank you for your patience this morning, ma'am. You have a good day, okay?
Thank you, Your Honor. Happy holidays.
Same to you, ma'am.
See you, Judge. Thanks much. If I don't see you beforehand, to you and your staff, a Merry Christmas. Take care.
Same to you. Thank you, sir. Yes, Mr. Mohammed.
Judge, so for the dynamic transportation ticket, they're seeking discovery. So I'm gonna have to reach out for the discovery for that. So we're seeking an adjournment. It's the overweight citation.
How long of an adjournment do you believe is necessary, sir?
I'll say 3 weeks, and the reason is I have to, I don't know if I don't even know how to reach this officer, so I'm gonna have to reach out to some contacts and see what I can do. So 3 weeks if that's possible.
I don't have the citation files with you. You said dynamic. Are you talking about Richard Vrooman?
It is. That's the one, Your Honor. Correct.
This is 3S4287632SI. 3-week adjournment will put us on December the 27th. Mary Ann, is there space available on that date?
At 9:15, Judge.
Thank you. December 27th at 9:15, that will be in number 3 by Zoom with Judge Green. Is there anything else on behalf of the people?
Nothing from the people, thank you.
Anything else on behalf of the defendant?
No, Your Honor. Thank you very much.
Thank you. Have a good day, sir.
You too.
Not when I still have a 10 o'clock case sitting.
So we got what they go here.
Um,
They send them on.
1, 2, 3, 4, 5, 6, 7, 8, 9. They can stay here. I don't know what's about to happen. Mary Ann?
Yes, ma'am.
Oh, I thought Mr. Mohammed was coming in. Maybe not. Thank you.
Okay.
Take your cap off for me, please, sir.
Judge, should I come out?
No, that was a false alarm. It's Perkins that showed up. Has Jamie been bringing you the citations? I'm looking for that Jonathan Stoddard that was adjourned over to next week.
Oh, let me look.
Thank you. It was scheduled at 9:15.
Your Honor, I have a question. I have a
Judge,
client.
I do not have Stoddard.
Thank you.
Welcome.
You have a client?
I have a client who is in custody at a Macomb. Do I send that information to the clerk to let them have to send a written?
You give it to the clerks.
Give to the clerk. Okay, thank you.
A client that's up when?
He is up, I think next week.
Next week?
Yeah, I think, so we might have to adjourn it. I just found out he was in custody. He's up on the 13th.
Three S
4286685,
State of Michigan versus Garacio.
Right here.
State your name for me.
Biagio Gracia.
Thank you, sir. You were scheduled this morning for pre-trial. There's an offer from the prosecutor for you to plead responsible to improper plates and dismiss the original plate violation misdemeanor. Was that your understanding?
I believe so.
That's how you wish to proceed?
Guilty.
No, is that how you wish to proceed?
Yes,
That's a
yes,
yes or
yes,
no.
I'm
Thank you.
sorry.
I know, I'm sorry for the language. The court will accept your plea of responsible to the added count of improper plates, dismiss the failure to register the vehicle. Court will impose a fine of $180. Do you need more than 5 days to pay that amount, sir?
Yes, please, Your Honor.
Before you leave, sir, you can stop downstairs at the counter. The staff will help set a payment plan in this matter, okay?
Thank you.
Anything else?
No, that'll be all.
Thank you, sir. You have a good afternoon.
Thank you.
I'm gonna jump in.
Get into your citation number and they'll help you set that payment plan.
Judge, I'll take 2 minutes to talk to officers and then we can start.
Absolutely. Thank you.
Yeah.
Mary Ann, Mr. Mohammed said 2 minutes, so more like 10, and we'll be ready to start the exam. Mr. Nunley.
Yeah, I just wanted to jump in and clarify that Mr. Bailey and Mr. Devine and Ms. Kirk were not assigned to me. I don't know who they are. They were, I believe, arraigned or maybe here for a day. I'm looking at the Register of Actions on November 28th. And I talked to Crystal about it, and she's received the discovery, I think, on 2 of them that have been specifically assigned to her. So I let her know, and she says that she's going to talk to them and she's going to cover them. I was only supposed to be here for a 9:45, just one individual pretrial, and I got a jet, so I offered to stay and help, but she said that it probably wouldn't help because she's just waiting for Mr. Mohammed, and she can knock them all out at one time. So she's got it covered.
Thank you, Mr. Nunley.
Yeah, I just wanted to let everybody know. So you guys have a great day, and I'll see you next time.
You too. Take care. I'm sorry, I was asking you, do you have your client's name for the 13th hearing?
Yes, I do.
I don't need it right just now. I'm trying to see if we can get what you need done.
Yes, ma'am.
Did it warm up in the front hall? Oh, Jamie came in here and he said he was doing something with the thermostats. You should have told him you had donuts and Hot Pockets.
Wait till it gets to be 20 degrees outside.
Our hot water did not work this morning because I think of how cold it was. It's awful.
Judge Oakley's secretary is not here right now, but I told her that you need to talk to her about this so you can get that done and make sure your client gets here.
Perfect. Thank you so much.
You're welcome.
No problem, no.
Marianne, step off for a moment. Mr. Muhammad still has people in his waiting room and Ms. Segura is in here for the 11:30.
All right.
Hi, everyone. Marianne, is there any way that you could give me the dates on Mr. Ryan Sarna again? I think it was January 3rd, but I'm not 100%.
What was the last name?
Sarna, Sarna.
time was he scheduled? I'm looking for him.
Oh, he was scheduled at 9 a.m.
9. Oh, yeah, I've got it. January 3rd at 9 o'clock.
That's what I thought. Thank you so much. And just to keep everybody informed, I'm waiting to speak to. I've just been waiting. Okay. Thank you.
I'm sorry, Miss Medina, were you ready with something? No, okay.
It's very cold in here, Judge.
Officer Garcia came in and tried to do something. I don't know
Did not work, huh?
if it helped at all. It must not have helped at all. Did they come down? Did all three, did the shades all come down?
Well, that was
No.
all it was. So he's aware.
It's coming right through the other one. I don't think it's gonna help.
It's better than a stick in the eye.
Yeah. Oh, it did a little bit.
We'll take it.
Do you want me to get Mr. Brown?
Are we ready on Brown or are you doing something else, Mr. Mohammed?
Oh, yes, we're ready on Brown.
Mary Ann? Oh, she's on her way. Did you bring your adjourn dates with you? Thank you. Are you kidding me with this?
Musical chair.
You want to hold it?
Probably everybody's best interest.
I'm ready. How are you?
I'm good, thank you.
Well, there are still people in the waiting rooms.
Is this new here?
I moved it because there was no place for the reindeer, which were more pressing than books. Yes. No, thank you. Well, there's a new tree. There's a purple tree to match the purple snowman. I'm making it work over here in this corner. Oh my God. Yes. Oh boy. It's like an old tarnished penny. How are you today, sir? Super. I could have gone home and had a grilled cheese. Silly me. I looked up at one point and somebody was laying in the bed. And I was just, I know, but still, you never get used to it. Oh, Mary Ann. I didn't call the case. I was waiting for you for the 11:30 case. Yes. This is 230221 FY State of Michigan versus Jonathan Brown. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people, PA 6771.
And good morning, Your Honor. This is the girl with the Neighborhood Defender Service on behalf of Jonathan Brown, P86432. Mr. Brown, will you state your name for the record?
Thank you. Today is the day and time set for the preliminary examination. There is count one, assaulting, resisting, obstructing police officer, and then there's a misdemeanor operating with blood alcohol content of 0.17 or more. Count three, operating while intoxicated. Count four, driving while license suspended, revoked, or denied, let suspended person operate, second or subsequent. Are the people prepared to proceed?
We are, Your Honor.
Defense prepared to proceed?
Yes, Your Honor.
Any preliminary matters, Mr. Mohammed?
Yes, Judge, we believe the testimony today may reflect 2 additional charges of assaulting, resisting, and obstructing a police officer. It would be Officer Timothy Shank and Officer Ryan Miller are the 2 additional charges. And that's gonna be under MCL 750.81B1.
And Your Honor, just for the record, the original charge is, it does state Ryan Miller and or Timothy Shank. So, I'm not sure if.
I did, Your Honor, disclose what each one is for to defense counsel prior to this. So one is stemming from initially what happened, and then it goes on to a second location, and 2 more are no charges arise.
Understood that that's your argument. Any preliminary matters, ma'am?
No, Your Honor.
Your first witness, Mr. Mohammed.
The people call Officer Shank.
Would you step to your right for me, please?
Oh, sorry.
Officer Shank, you come up to this podium for me, please? State your first and last names for the record and then spell them both.
It's Timothy Shank, TimothyShank.
Raise your right hand for me. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you much. Come up here, please. Have a seat in this black chair that's closest to me. Mary Ann is recording your testimony. If for some reason she's unable to hear you, I'll ask you to either raise your voice or get closer to the microphone, okay? Thank you. Your witness, sir.
Good afternoon, officer. Can you please state your name for the record?
Yes, sir. It's Police Officer Timothy Shank.
Officer Shank, are you currently employed?
Yes, with the Romulus Police Department.
And in what capacity are you employed?
I am a sworn police officer.
And for how long have you been employed?
With the Romulus Police Department, 3 years.
Were you employed in this capacity as a police officer on January 24th, 2022?
Yes, sir.
And did you work in the state?
Yes, sir.
Did you work in the state by yourself or with a partner?
I was by myself.
And on this day, were you working in full uniform or modified uniform?
Full uniform.
And on this day, did you work foot patrol or were you in a scout car?
I was in a scout car.
And was this scout car marked?
Yes.
Can you give a brief description of what that entails?
Decals on the vehicle and a light bar.
Light bar?
Yes, sir.
Does it say Romulus Police anywhere?
Yes, the decals do.
And did your duties as a police officer on that day take you at or near 9152 Inkster?
Yes, sir.
Is that located in the city of Romulus, County of Wayne?
It is.
So what took you to that location?
A call for an accident.
So where you were dispatched?
Yes, sir.
And the nature of this dispatch?
An accident, vehicle accident.
Okay, and did you approach this location?
Yes, sir.
And this was in your scout vehicle?
Yes, sir.
And what, if anything, did you observe at this location?
I observed the suspect vehicle parked in the parking lot.
So you observed a vehicle parked in a parking lot?
Upon my approach, yes.
Okay, and what did you do after that?
I approached the vehicle.
And what did you observe when you approached this vehicle?
The suspect sitting in the vehicle.
And was there anything about the suspect that brought your attention?
He was asleep in the vehicle, slouched over the center console.
Okay, and did you try to make contact with him?
Yes, I opened up the door and addressed the male.
Okay, you in what?
And addressed the
Can
male.
you speak up a little bit louder?
Yeah, addressed the male.
Okay. And
Yes, sir.
Did that male respond?
Yes, he woke up.
And this male, was there anyone else in the vehicle?
No, he was by himself.
And this male, where was he seated?
He was seated in the driver's seat.
And this male, do you see him in the courtroom today?
Yes, I do.
Can you please point to that individual and point out an article of clothing?
Yes, he's sitting right there in the defendant's seat, wearing a tan jacket and blue button-up shirt with a mask on.
Can you please ask your, and just to confirm, this is 100% the person you saw on that day?
Yes.
Your Honor, please let the record reflect this ID of the defendant.
Yes, sir.
Thank you. And so what did you do after that, after you initiated contact with this person?
I asked him to step out of the vehicle
Why did you ask him to step out of the vehicle?
so I can speak with him and for officer safety reasons,
What was the safety reason at that point?
to speak with him outside of the vehicle.
Okay. And when you spoke to him, did you notice anything?
He showed signs of intoxication.
What are these signs?
He had slurred speech and there was a strong odor of intoxicants coming from his breath and body.
Okay. And just to mention, just to, go back a step, he was sleeping when you first approached, correct?
Yes, he was.
And did you notice anything in regards to the vehicle? You said you were dispatched there for an accident.
Yes,
Did you notice an accident?
there was accident damage to the vehicle.
There was.
Yes.
And when you asked the individual to step out of the vehicle, did they comply?
Yes, he did.
Okay. And then you just initiated a conversation, or what occurred after that?
Yes, I conducted an investigation, trying to, conducting an interview, asking him where he's coming from and what brings him to the location.
Okay. And did anything occur during this conversation?
In regards to what, sir?
In regards to why we're here today?
I'm not understanding
Okay.
the question.
I can rephrase. Did you recover anything?
Did I recover anything? Yes, sir, I did.
What did you recover?
A knife,
Why did you recover the knife?
for officer safety reasons, sir.
Where was this knife located?
It was in his pants pocket.
Did you ask him for the knife, or did you just?
No, I observed it.
Okay.
I observed it hanging out of his pants pants pocket. I saw the clip, and I reached down and I grabbed it out of his pants pocket for officer safety.
Okay. And did anything occur after you recovered this weapon?
Yes, he attempted to reach for it, and he touched my hand trying to grab the knife.
Was he successful in recovering that weapon from you?
No, he was not. I deflected his hand with my other hand, and my partner, Officer Paquette, immediately put him in handcuffs.
Okay. And when he reached for this weapon, how did it make you feel?
Threatened.
And so what did you do after this? After you detained the individual, what occurred after that?
Following his detainment, we continued on with our OWI investigation. Based off of our observations, we asked him to submit to a PBT. He consented to the PBT.
What's a PBT?
A preliminary breath test.
Okay.
And it resulted in I don't know exactly what the results were. I would have to look at the report. I don't have a copy of it, but he definitely blew over the legal limit of 0.08.
Okay. And then what, if anything, did you do after that?
At that point, he was under arrest for OWI. We read him his chemical test rights verbatim from the DI 177. He consented to a blood draw. We transported him to the hospital for that blood draw. It was conducted there, then transported him back to the Romulus Police Department for booking and lodging.
And you said you transported him from the hospital back to the station, is that correct?
Yes, sir. From the scene to the hospital, from the hospital to the station.
Okay, and did anything occur at the police station?
Yes, he resisted during the booking process.
How did he resist?
So we asked him to remove his multiple layers of clothing down to a minimum of 1 layer per department policy. He argued about it, so I had my sergeant come in and explain the policy a little more in depth. We then allowed him to have the opportunity to have privacy in an interrogation room where he removed the multiple layers down to 1 layer. He then attempted to add on an additional 2nd layer of clothing, which was his jeans. We advised him that he could not, and he immediately tried putting the jeans on. We grabbed a hold of him and he tensed up, and we brought him out into the booking area, and he fell to the ground, and we tried to give him verbal commands to remove the clothing, to remove the pair of jeans, and he would not release his grasp of the jeans. I tried to remove the jeans physically, and I tried to remove his hand physically from the jeans, and I was unsuccessful. His jeans then tore, and he was finally able to release the jeans.
So why wasn't he allowed to have the extra pair of pants on?
Per department policy, it's for the safety of the prisoners inside the cells, for the safety of themselves from preventing them from attempting suicide, along with for the safety of other prisoners, so they don't get physically assaulted with the clothing.
How many times would you say you asked him to remove the article?
I don't recall. More than once, sir.
Did you observe Officer Miller or Sergeant Miller make any attempts as well?
To remove the clothing?
Or any
I don't recall what Sergeant Miller was doing at the time. I know that he was giving verbal commands as well.
Do you recall what those commands were?
To remove his jeans.
And did the individual that you identified earlier comply with those commands?
No, his jeans had to rip, and he no longer had a grasp of them, and that at that point is when he began to comply with verbal direction and physical direction.
Do you recall how many lawful commands Sergeant made, Sergeant Miller?
I don't recall.
No further questions for this matter.
Thank you. Pam?
Good afternoon, officer.
Good afternoon, ma'am.
Did you prepare a report in this case?
Yes, I did.
And did you review that report prior to submitting it
Yes, I did.
to ensure it's an accurate representation of the events that occurred?
Yes, ma'am.
And did you review that report prior to your testimony today?
I did.
Did you find any inaccuracies in that report when reviewing it?
Not to my knowledge.
Okay. When you arrived on scene, it was because of an accident, you stated.
Correct.
And when you made contact with Mr. Brown, he seemed to be intoxicated.
Yes, ma'am.
And a preliminary breath test was taken at the scene.
Yes, ma'am.
You indicated you don't remember the exact level, but it was over 0.08.
Yes, ma'am. I believe it was 0.172, but I'm not exactly sure.
Okay, so roughly twice the legal limit.
Absolutely.
And he was pretty intoxicated.
Yes.
And you indicated there were signs of this intoxication.
Yes.
He was slurring his speech.
Slurred speech.
He was struggling with his coordination,
Yes, ma'am.
swaying back and forth.
Yes, ma'am.
And he even had to correct his footing a few times
Yes, ma'am.
to keep from falling over.
Yes.
And when you made contact with him, you had asked him for his ID. His
Yes.
license.
Yes.
And he reached to grab his license. Did he reach to grab his license?
I believe so.
And at this time, this is when you observed the
I'm
guy?
not 100% sure.
Okay, but so he was grabbed while he was reaching for his wallet, you observed the knife?
At some point in time, I did observe the knife. I don't know exactly when
Okay.
I
Were you-
observed it.
Okay. Were you wearing body cam footage at the time of the incident?
I was wearing a body camera, correct? Yes.
Would you be able to recognize that if I would show it to you?
Yes, if you have the video.
I do. You're on me, I approach.
Absolutely.
Okay. We got they ended up with it. I'm starting at 151.
Okay.
Volume's up.
Do you have your driver's license on it? That's the ball. Where's the roll? Right? No.
Okay, I'm stopping at 210.
Okay.
Do you recognize what it is I just showed you?
Me slapping his hand away from my hand.
Is it your body cam footage though?
Yes, that is my body camera footage.
Does it appear to be an accurate representation of the events that occurred that night?
Absolutely.
Does it appear to be altered or tampered with in any way from the clip that I showed you?
I don't believe so.
Okay. Your Honor, at this time, defense moves to admit proposed exhibit A into evidence. It was minute 151 to 210.
Any objection?
Judge, we just asked that entirety be admitted.
I'm going to object to that request. My only request is to admit this small snippet.
Well, Judge, then I would object because I can see it being like potentially a misrepresentation of what happened if it's just showing like a very small fraction, like a few seconds, but maybe not the incident that led up to that or what occurred after. So respectfully, Judge, I'm just asking, I have no objection to admitting it, but just everything.
Admit the video, the body cam in its entirety?
Yes, into evidence if she's moving to admit it to evidence. We don't have to play it, but if she's moving to admit it.
Your Honor, my only response would be that if that's what the prosecutor wants to do, that then they can do that. But for my purposes only, I'm just admitting what we just testified to in regards to this alleged reach for the knife.
Over the prosecution's objections, the court will receive as defense exhibit A, the body cam video of Officer Shank from 151 to 210.
Thank you, Your Honor. Okay, and 1 second. Okay, and you indicated that, so after this incident, Mr. Brown was then put in handcuffs
Yes.
and fully complied to this
Up until the station, yes.
up into the station. Okay, and at the station, you indicated that he was instructed to remove all but one layer of clothing.
Yes.
And so at this time, he had on, obviously underwear.
He had he had multiple layers of clothing on.
Right. So he had a pair of underwear, long johns, shorts, and jeans. Is that accurate?
I believe so.
Okay.
I don't exactly recall.
Okay, and he was instructed to just remove all but one.
All but one, yes.
And this is part of the booking process.
Correct.
It's a policy of the Romulus Police Department.
Yes.
Do you know what policy number that is?
No, I do not.
No. How did you learn of this policy?
I was instructed by my command that it is policy.
When were you instructed of this command?
When I began working at the Romulus Police Department.
Okay. And Mr. Brown didn't seem to comprehend this policy.
Yes.
So eventually he was given a room for privacy
Mhm.
to remove the layers of clothing.
Yes, sir.
And he removed the jeans and then the shorts. Is that correct?
I don't recall exactly what he removed first.
Okay.
I do recall that he removed multiple layers down to his long johns and then attempted to put on a second pair of jeans.
Okay. So he removed the jeans, the shorts, long johns were still on, and then proceeded to put the jeans back on.
Yes.
Okay. And then this is when the sergeant interrupted Mr. Brown from doing this.
I'm not 100% sure if he interrupted first or if I interrupted.
Okay. And at this time, what were you doing?
I was standing there.
You were standing.
Yes. Yeah. Yes, ma'am. I was standing there waiting for him to come out.
Okay. And when he was told to, you know, stop putting his jeans on, he was not very responsive at that time.
Correct.
And he was then taken to the ground.
Yes,
And all he kept saying was, "Excuse me."
I don't recall.
Would you be able to recognize body cam footage from the incidents if you were to see it?
Yes.
Your Honor, may I approach?
Yes. Is there one video that you're pulling clips from, or is there multiple videos?
This is a second video. I think there were 7 videos that I was provided. Unfortunately, Your Honor, when the videos were sent, there is no like indication as to whose this body cam footage was. I have a lengthy number. It's titled by a really lengthy number. I can provide that to the court.
No,
Okay.
just curious,
Okay, apologies.
because
Yeah.
I'm assuming that when you move for a submission, Mr. Mohammed may have the same objection,
Yeah,
and this court is not inclined to watch. Okay,
yeah, I understand.
Thank you.
This is a different video, clip from a different video.
okay.
Okay. So I'm starting from 3:10. So I'll just play, I'm gonna play up to 5 minutes, so it'll be about a 2-minute clip. And then I'll ask you some questions, okay?
Okay.
I'll stop it at 4:30. Okay, do you recognize the footage that I just showed you?
Yes, it was my video footage.
It was your video footage, okay.
Yes, ma'am.
And did it appear to be an accurate representation of the events that occurred?
Yes.
Does it appear to be altered or tampered with in any way?
It was a little fuzzy at the end, but I don't believe so.
Okay, Your Honor, at this time, defense moves to admit proposed exhibit. I believe I said, let me see, 3:10 to 4:30 of Officer Shanks' body cam footage.
Any objection?
No objection.
It's received.
Thank you, Your Honor. Okay, so let me just re-ask. So during this time, all he kept saying was, "Excuse me," or at least repeatedly saying, "Excuse me."
Yes.
And at some point he asked, "Can someone tell me what I did wrong?"
Yes, he did ask that.
And then his pants were ripped off of him.
I did rip his pants off, yes.
You ripped pants off?
Yes.
Okay. Okay, and then I'm gonna show you one more clip. Because I'm gonna ask you this question and I'm sure you're not gonna remember, but I will ask it before showing. So at some point, roughly 30 seconds after this incident occurred, he apologized for not understanding.
I'm not aware of that. I don't recall that.
Okay. You're on me, Coach.
Yes.
Gonna show you 3 seconds. I stopped it at 5:40. Do you recognize what it is I just showed you?
A video footage, unknown of whose video footage, but a video footage.
And your honor, just for the record, it is the same video that I just showed Officer Shank. It is just now fast forward to 5:40.
It ended at 5:40? Or you
No,
started
this-
at 5:40?
Yeah, so I apologize. I started it at 5:35, and I stopped it at 5:40.
What
So
happened between 4:30 and 5:35?
Just them taking him, I didn't want to waste the court's time, but it's just taking, for offer of proof, taking him from the ground, taking his pants off, setting him on the chair, and the officer's kind of collecting the clothes. So it's not anything substantial. Okay, so then you recognize this footage as Mr. Brown in the police department?
I don't recall seeing Mr. Brown in that clip, but I heard his voice in it,
Okay, and does it appear to be altered or tampered with in any way?
not to my knowledge.
And does it appear to be an accurate representation of the events that occurred?
It appears so.
Okay, and then just for clarification, at this time, your honor, defense moves to admit proposed exhibit C into evidence. Same video clip as last time, or same video as last time, but I am now moving to admit minutes 5:30, 5:35 to 5:40.
Any objection?
No objection.
It's received.
Thank you, your honor. Okay, so then just to reiterate, at that point, he did apologize for not understanding.
In the video,
Yes,
yes, his voice was heard apologizing.
thank you. I have no further questions, your honor.
Any redirect?
Nothing further.
Thank you. Officer Shank, thank you for your testimony. You may step down.
Thank you, Your Honor.
Your next witness, sir?
No more witness.
Any witnesses, ma'am?
No, your honor.
Argument.
Judge, I'm going to request that this case be bound over to circuit court in regards to the counts as listed on the discovery. I'm not moving to bind over on any additional charges. The Officer Shank's testimony today reflects that he responded to a dispatch call, and upon, approaching this location, he identified the defendant as the driver and made contact with that person. He asked the individual to come out of the car for safety reasons. Obviously, the defendant appeared very impaired. He had just crashed the vehicle. The officer, for safety reasons, removed the weapon, which was a knife located on the defendant. And the defendant then attempted to reach for that weapon back. And I believe at that time, that the defendant meets the elements for this crime of assaulting, resisting, and obstructing. The assault, so I have to show that it was either assault, batter, wound, resist, obstruct, oppose, or endanger when officers. I believe assault has been met. I believe battery has been met. He's resisted and he's opposed. I only have to show one, judge. The assault occurred because the testimony by the officer was that he felt in fear. Someone was going for the weapons that he just recovered. I believe that's reasonable. Battery occurred when there was that unlawful touching, and it was offensive to the officer. He didn't ask him to touch him. He just made contact. The defendant also resisted and opposed the officer. Resisting and opposing doesn't have to be a verbal command. It could be, through conduct. If the officer who's acting in his lawful duties, remove something, doesn't mean I can just go and reach for it and take it back. So I believe in regards to assaulting, resisting, and obstructing Officer Shank, I believe that testimony today reflects it, and I move to bind over on that count. And in regards to the additional counts, I'm not going to move to bind over on those. Thank you.
Thank you.
Your Honor, we would object to the bind over in this matter. For one, I'm a bit confused exactly as to what conduct the prosecutor is alleging that was the overall charge, whether that was like with the gun or the pants. But either way.
I'm sorry, did you just say gun?
I mean, sorry, I apologize. The knife or the pants. But that was All of this, I believe, is just a clear misunderstanding. The incident occurred, or they were dispatched to this incident because of an alleged intoxicated person, first involving an incident. Then upon approaching Mr. Brown, they believed that he was intoxicated. And they indicated that he did take a preliminary breath test and he blew roughly around a 0.17, which is twice the legal limit. And he was clearly intoxicated, as the officer testified to. The officer also testified that Mr. Brown did not seem to comprehend why he was being asked to remove all of these clothing, and he was supposed to only go down to one layer of clothing. The body worn camera footage shows that Mr. Brown was not responsive when the officers came into the room to remove his jeans. He was almost statue-like, and I will show that to the court so that you, Your Honor, can review that. I think it is a note or a point where it's noted. So I'm going to back up into 310. Your Honor, may I approach?
Yes, ma'am.
I'll play it from 310, I think.
Charges. Yeah, just stop. Listen, Mr. Brown, just stop. Only thing is, Mr. Brown's Brown, all right? Yeah, so look, you gotta stop. Mr. Brown, stop. Just come on out here. Excuse me. Come on. Okay. Excuse me. Go over. Excuse me. Go over. Get him on the stomach. Excuse me. Excuse me. Excuse me. Mr. Brown, excuse me. Please. Excuse me. Why are you making, excuse me. Excuse me. Excuse me. What did I do? Excuse me. Why am I on the stomach? What did I, excuse me. Excuse me. What did I do wrong? Excuse me. Excuse me. Excuse me. Excuse me. I'm trying to get on. Please talk to him. Please. That will tell me anything right now. Are you kidding me? I'm just asking. So he's gonna tell me.
I think this is where I stopped it, Your Honor. But as you can see, when he was told to stop removing his clothes, he was kind of statue-like and he wasn't moving. And when he realizes what is happening, all he's saying is, excuse me, and he asks, can someone please talk to me? Can someone please explain? And obviously we see where the result is that his pants are ripped off of him. He's clearly not understanding what is going on, why he's being tackled to the floor and having his jeans ripped off of him. Eventually, as we heard in the body cam footage, eventually he apologizes for not understanding and then allows the officers to remove the necessary clothing. Yet we are here today in front of the court for a misunderstanding that led to Mr. Brown being charged with a felony. And we are not excusing his drinking, the accident, whatever led to the initial dispatch. But what we are asking is for the court not to bind over this case because Mr. Brown failed to comprehend what was being asked at him at this booking process. And he clearly was severely intoxicated. And if Your Honor, you're not persuaded by that argument, I just ask that this case not be bound over because we are not prevented with the policy, or we are not provided with the policy that the people are stating that Mr. Brown failed to abide by. I had asked the officer what that policy number was, and he couldn't even provide that to us today. So truthfully, we don't have anything other than his testimony indicating that this policy exists. And so for those reasons, we would ask for the this case not be bound over to circuit court.
Thank you.
So in response, Judge, the defendant wasn't statue-like when he reached for the knife. You know, he wasn't statue-like when he was initially removing clothing. He wasn't statue-like when he was adding additional clothing after the officers indicated to him to stop. It's common for offenders to make their body go dead weight, so they act like they're, you know, not understanding, but they're just making their bodies, you know, they're resisting the arrest, they're resisting the officer by just making their body go stiff. So I don't really see that. And we, you know, Judge, this is a probable cause standard, and we believe we've met our burden. And yeah, I think without question, probable cause has been met here. And we respectfully still request to have the space bound over. Thank you.
Your Honor, if I may, just briefly address the knife allegation. The officer testified that at the time that Mr. Brown, that he approached Mr. Brown, he was exhibiting signs of intoxication. He was slurring his speech. He was unsteady on his feet. He lacked coordination. He had to adjust his balance multiple times in order to not lose his footing and fall. And I can even provide that footage quickly to the court, Your Honor. I don't need to drag this out, but I think.
I'm sorry, 1 second. I hear a phone ringing.
Yeah.
He had to adjust his footing.
Yeah, he had to adjust his footing, and the body cam footage from Officer Shank at that point, I will play it for the court, so you also can see it. May I approach?
Yes.
Video is not that great. Okay.
Is the vehicle registered to you? Do you have your driver's license on you? First of all, no.
I think that's the point where I stopped it. But at that point, Your Honor, I don't think that this is a situation where Mr. Brown wasn't lunging at all. I think it's just, he may possibly have lost his footing if he was as intoxicated as the officer described. So just to address the, reaching up the knife, I just wanted to put that on the record.
Anything else, Mr.
Just
Mohammed?
very brief, and Judge, if that is plausible, I mean, that would still be a question of fact for the trier fact, and nothing further.
Thank you. The court has had the opportunity to view 2 of the clips that were received this afternoon and hear the testimony of Officer Shank, and will bind Mr. Brown over on the felony count of resisting, obstructing, and assaulting a police officer. It is this court's opinion that based on the testimony of Officer Shank, who indicated under oath that he was performing his lawful duties, he was in a fully outfitted police car in full police uniform, giving Mr. Brown specific instructions on things to do or not do as part of the arrest and the booking process, and Mr. Brown did not comply as requested. Officer Shank also testified that he was in fear at certain points or fearful at certain points based on Mr. Brown's behavior and or response to requests or directions from Officer Shank to Mr. Brown. The next step in these proceedings will be an arraignment on the information, which will be on December 20th, 2023 at 9 a.m. Mr. Brown's previously entered bond with any of its restrictions will continue. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, ma'am?
No, Your Honor.
Thank you. That concludes this matter. Mr. Brown, you're free to go.
Thank you.
During the exam, on the Mark Taylor matters, this court was made aware of the fact that Mrs. Tieppo was not going to be able to appear in person, would be.
I mean, we both are in stipulation to an adjournment for the 4 cases, so there is a lot of discovery issues with that. I'm surprised it was set for an exam, so I'm requesting to.
He's not here.
The defendant's not here.
Then we're gonna pass this matter. I'll bring Ms. Tieppo in and let her know that. We have cases that are still waiting from this morning's docket. Mr. Mohammed.
Next one is a waiver.
That still puts us behind. Mr. Mohammed, what this court is inclined to do, are these people who are waiting from the 9:30, the 10:45, the 10 a.m. dockets to just adjourn these matters over? I can do that in your absence. Or if your associate wants to stay in the room and hear the adjournments, the court can do it that way as well. I just want to get these people released that have been here.
Yeah, of course.
Thank you. Ms. Tieppo.
Yes, hello, Your Honor.
Good afternoon, ma'am. Today is a day and time set for the preliminary examinations in 200096 FY, 2000 97 FY 200094 FY 200095 FY. These were all State of Michigan versus Matthew Mark Taylor. Your appearances, please.
Mohammed on behalf of the people, P86771.
Good afternoon, Rebecca, TFOP 62311 on behalf of Mr. Matthew Taylor as to all cases.
Thank you. Today was a day and time set for the preliminary examination in these matters, and Ms. Tieppo, the court understands and appreciates your inability to get here. And before the case was called, Mr. Mohammed indicated that an adjournment might be in order, but this court's bigger concern is that these cases are older cases. Mr. Taylor is not here. He was physically here in court when these matters were adjourned to today. Do you have an explanation for his failure to appear as directed by the court?
No, actually, I had no idea he was not in court. The issue that I had broached with the prosecutor is that although we did speak in the last couple of days, and I let him know I had not yet received discovery, I still have not received discovery. I think maybe the prosecutor's changed a few times, and the defense attorney has changed a few times, I believe, prior to me coming onto this case. But regardless, I don't feel comfortable moving forward without discovery in advance. And as to my client's whereabouts, this is no, I didn't know he was not present.
Judge, if I may.
Yes, sir.
In regards to discovery, paper discovery was sent to Ms. Tieppo, and Ms. Tieppo is correct that the prosecutors have changed. And initially I wasn't the one who set this for an exam, but I did notice that digital discovery was missing on 3 of the 4 cases. I did speak to Ms. Tieppo, and we did reach out to the OICs for the case to try and get this resolved. And it was my understanding today we were going to do a stipulation for an adjournment. But based on the defendant just failing to appear, I think that requires a capias at this time.
Ms. Tieppo?
We would, and sorry to cut you off, Judge. The people would also like to do a global resolution and resolve all 4 at once in regard to one resolution. So Ms. Tieppo, if you can please reach out to me. I tried to make numerous calls the past few days, haven't been able to get in contact with you. But yeah, we would like to, resolve all of these. So please reach out when you can.
I would certainly be willing to do that. Your Honor, I would just ask the court to provide me an opportunity to try to reach my client, find out what the issue is. I believe he has appeared on all the prior dates, but I can't speak to his non-appearance today.
Judge, I would object only because there is 4 exams. It's not 1 or 2, but there's 4 different hearings. And
Ms. Tieppo, respectfully, the court will issue bench warrants in all 4 of these cases based on the defendant's failure to appear. He has appeared previously, and the last time we were here, he expressed his dismay that we were not going forward and were in fact adjourning these cases. The victims are here again for, I think, the 3rd time in this courtroom. I know that the matter had 2 of the other judges in this building had disqualified themselves previously, and there had been a visiting judge sitting at some points in these cases. But Mr. Taylor was here the last time. The court confirmed the date and said we were going forward. He had another matter that the court apprised him of. He failed to appear this morning. If you're able to get a hold of him, you of course can reach out to the court on his behalf, and we can recall the warrants and get these matters rescheduled. But at this time, based on his failure to appear, bench warrant shall issue 10% in all 4 of the files that are before this court for exam this afternoon. Is there anything else in this case, these cases, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Ms. Tieppo?
No, thank you so much, Your Honor.
Thank you. That concludes these matters.
Thank you, Judge.
You're welcome, ma'am. Give me just one moment, okay? Thank you. There's nothing else on Zoom this afternoon, right? I'm gonna close these rooms so I can force these people out.
Hello?
Good afternoon. Give me
Yes,
one
ma'am.
moment.
That's fine.
My apologies to all of you who have been here on this docket for hours now for reasons that I'm only able to offer apologies for. We are going into our exam docket, which started at 11:30, and Mr. Mohammed, the prosecutor assigned to this courtroom, is now unavailable to take up any of these remaining matters from this morning. That being the case, these cases will all, anybody who is still here, your case will be adjourned. We'll get you a new date and time in just one moment. Mr. Powers in 23L027372I Waste Management. That case will be adjourned to December 13th at 10:15. That will be live here in courtroom number 2 with Judge Oakley. Notice will be mailed out to you at that address.
Okay, I'm sorry, that's.
The address we have on record.
What time is
I'm
that?
sorry,
I apologize. What time?
10:15.
10:15, the live in court?
Yes,
Okay,
thank you.
all right, thank you, Your Honor.
Regina Zoom.
23L117920, State of Michigan versus Joseph Olszewski, OLSZEWSKI. This case is being adjourned to December 13th at 10:15 a.m. That will be in person in courtroom number 2 with Chief Judge Brian Oakley. You are free to go, sir. This is 23N22, you're welcome, 7097 A and B. These are State of Michigan versus John Harvey Downs. Mr. Downs, you waive your right to have the assistance of the court-appointed attorney, but this, I see you, sir. We are unable to get to your matter this morning. You are being adjourned. Your new court date will be December 13th at 10:30 a.m. That will be in person in courtroom number 2 with Chief Judge Brian Oakley. My apologies, sir.
You're all right.
You're free to go, sir. You have a good day.
Thank
This
you,
is
ma'am, very much.
230. You're
Thank-
welcome. 230851 SD, State of Michigan versus Charlene Kirk. Ms. Kirk, she's on the 11 o'clock docket.
And Your Honor, I would be handling Ms. Kirk.
I know Ms. Medina, and my apologies, but we're in the throes of the exam docket now. Mr.
Oh, no.
Mohammed is.
Oh, no.
Had you spoken to Mr. Mohammed regarding Ms. Kirk?
No, Your Honor, I had not gotten a chance. I was just indicating in terms of like dates and stuff that I checked, yeah, for Ms. Kirk.
Thank you. That new date will be December 13th at 10:30. That is in person in number 2 with Judge Oakley.
Your Honor, I am unavailable for that day. I am Lincoln Park House Counsel, but I guess like if that's the next date, I don't want to inconvenience. Ms. Kirk
Do you want us
either.
to, would December 20th be better for you, ma'am? Or you House Counsel?
December 20th would work well, Your Honor.
Ms. Kirk, December 20th at 9:45, notice will be mailed to you at the address we have on file. Mr. Downs, sir, you're free to go. You can just exit through that door on your left, please.
Thank you very much, ma'am. When was
You're
my
very
next
welcome.
date? When was my next?
I'm sorry?
date? When was my next date here?
It's December the 13th, sir.
Thank you.
at 10:30 a.m.
Thank you.
And
Thank
Your Honor,
you.
Your Honor, Ms. Kirk on the 20th, would that be in person and Judge Oakley as well?
It is.
Okay, thank you.
Thank you. And then Mr. Stokes at 230799 SM.
Spoke with him. Mr. Stokes?
1220 at, I'm sorry, 1220 at 9:45. That's in person with Judge Oakley and number 2. Mr. Stokes is here and has been here. Notes will be mailed to him at the address we have on file. Thank you, Ms. Medina.
Thank you, Your Honor.
Mr. Holmes, this is 3S4275357ST.
He dismissed it.
This was on the 10:45 docket. Mr. Holmes, your case is being
Because,
adjourned to
Whatever. I gotta find out from somebody.
December 20th at 10 a.m. That's in person in number 2 with Judge Oakley, sir.
I gotta find out. I gotta go to the desk.
Ms. Devine. Mr. Devine, 10:45. 230816 ST, Armand Devine, Miss Medina. 1220 at 10 a.m.
Thank you.
Thank you. You're free to go. Thank you.
Oh, wait, what was the date?
December 20th at 10 a.m., sir. Thank you. Mr. Khan for Badger Transportation.
Good morning.
Did you speak to Mr. Mohammed?
Unfortunately, I didn't. Otherwise, I'm sure we would have resolved this, Judge. But if my matter needs to be adjourned, I just want to let the court know I will be out of the country from December 18th to January 5th. I would not be able to conduct a Zoom or appear in person. I'll be in Asia.
What time was your client's case scheduled, sir?
10:45.
Oh, I see you at 10:45. We can put it over to the January 10th docket. January 10th at
January 10th?
9:30 by Zoom with me. Yes, sir.
Oh, perfect. Thank you so much, Judge. So January 10th with
welcome.
you. Thank you very much.
Yes.
And
9:30
what
by
time?
Zoom.
9:30 by Zoom.
Yes.
Thank you,
Thank
Judge.
you.
Have a good day.
You're welcome. Three S4201374B, State of Michigan versus Joseph Habush.
Yes, ma'am.
Sir, unfortunately, the prosecutor was unable to get to your matter this morning. This court has now moved on to its felony exam docket. Your case will have to be adjourned. That adjourned date will be December 20th at 10:15. That's in person here in courtroom number 2 with Chief Judge Brian Oakley. Notice will be mailed to you at the address on file with the court.
All right. December 20,
Yes, sir.
what time?
At 10:15, sir.
10:15. All right. Thank you so much, ma'am.
You're so welcome. Miss Garion, 3S4297177SI, State of Michigan versus Aldo Sala.
Yes. What date would that be, Judge?
I'm waiting to get one from Mary Ann. Give me 1 second.
I'm
December
good to go, ma'am.
20th at 10:30 a.m. That's in person with Judge Oakley in number 2.
Perfect. Thank you, Judge. Have a good one.
Thank you. You're free to go. Heather, don't leave. It was Ms. Segura who had I think it started with a G, shoot. I don't know if she's still on the hallway, but her client's in Macomb County. Whatever's on your docket for next week, she wanted to know if she needed to send the writ or we did. I said, we'll talk to Heather about it. Mr. Sanders, I don't see your attorney here. She had been on previously when the case was called and we were going to adjourn the pretrial.
Yeah, she was supposed to be meeting with Mohammed and was apparently still waiting. I have to work tonight and haven't gotten any sleep. I worked 12
I know, Mr. Saunders, we'll put this matter over. December 20th at 10:30, and we'll send notice over to your attorney. That will be in person in courtroom number 2. Notice will be mailed to you at the address that we have on file, okay?
Is that 12:20 at 10:30
Yes, sir.
in person?
Yes, sir.
All right, thank you, Your Honor.
Thank you.
You have a good one.
You too.
All right, bye.
And then from the 10:30 docket, Mr. Crawford, 230872 SM, State of Michigan versus Mark Anthony Crawford. Ms. Medina, I see you. We'll put this matter over to the 12:20 docket at 10:45 a.m.
Thank you guys very much. I will be signing out now. Have a great rest of the day, okay?
Thank you, you too.
And I'm sorry about that confusion this morning, although I think that was the least of the day's issues, Your Honor.
No worries, ma'am.
Thank you.
Have a good day.
You as well.
Two 230200 FY, State of Michigan versus Robert Earl Flowers Jr.
Good afternoon, Your Honor. Patricia Mandernack for the people, T840888. Good afternoon, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Mr. Flowers, who stands to my right. Mr. Flowers, state your name for the judge, please.
Robert Flowers.
Thank you, Mr. Flowers. Today is the date and time set for the preliminary examination in this matter. There is count 1, assault with intent to commit bodily harm less than murder. Count 2, misdemeanor, domestic violence aggravated. Are the people prepared to proceed this afternoon?
Yes, Your Honor.
Defense prepared to proceed.
Your Honor, I have spoken with my client about his right to have a preliminary examination where the prosecution would have to prove by probable cause that a crime was committed. He was the one who committed that crime. At this time, he is choosing to waive that right, knowing that he'll be bound over to the Third Circuit Court for further proceedings.
Thank you. Mr. Flowers, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You were able to hear Ms. Pilkowitz just now?
Yes.
Is everything she said true and accurate?
Correct.
You understand, you may put your hand down, I'm sorry. You understand you have an absolute right to have an exam in this matter. You wish to waive that exam?
Yes.
And you weren't threatening in any way or promising anything to get you to waive the exam? No. I passed the file down. Ms. Pilkowitz has signed where you're waiving your right to have that exam.
Yes.
And Ms. Mandernack, is the older form that does not have a space for you to sign is not having an objection to it?
I have no objection, Your Honor.
Thank you. Mr. Flowers, the court is finding that your waiver of your exam has been freely and voluntarily given. And as soon as the prosecutor affixes her signatures to the waiver form, Officer Brooks will bring it back. The court will sign it. And then you would be bound over as charged. Your next appearance date, thank you, sir, will be an arraignment on the information, and that will happen at the Frank Murphy Hall of Justice on December the 20th, 2023 at 9 a.m. Your previously entered bond with any conditions will continue. Is there anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of Mr. Flowers?
No, Your Honor.
Thank you. Mr. Flowers, that concludes this matter, sir. You're free to go. You have a good day.
Thank you.
You're welcome.
Have a good day, everyone.
You too. Thank you.
Over here.
Mr. Koenig in 230880 SM, State of Michigan versus Koenig. Would you state your name for me, please, sir?
Anthony Joseph Koenig Jr.
Sir, I have to offer you my extreme apologies for reasons beyond the control of the court. The prosecutor was unable to meet with Ms. Medina prior to commencing our exams this afternoon. For that reason, your case will have to be adjourned.
Okay.
That adjourned date will be, give me just one moment. Give me 1 second. I need the, an adjourned date, please. Final pretrial for Mr. Koenig, Koenig. 12:20 at 10:45 a.m. It will be back here in person in courtroom number 2. So when you come in on December 20th, sir, come upstairs and check in with the court officers. And they
Sounds
will
good,
get
thank
you
you.
into, I'm sorry.
I said, sounds good. Thank you, Your Honor.
Thank you so much for your patience, sir. You have a good day.
You as well. Thank you.
Thank you. What's the good news? Thank goodness. How do I still have this? File? Good afternoon. Your name, please, sir?
Victor Stokes.
Mr. Stokes, the prosecutor was unable to meet with Ms. Medina, the court-appointed attorney who was available this morning. For that reason, your case will be adjourned. Ms. Medina was present. That adjourned date is December 20th, 2024 at 9:45 a.m. in courtroom number 2 in person with Chief Judge Brian Oakley. Notice will be mailed to you at the address we have on record. Anything else, Mr. Stokes?
Repeat that again.
December 20th at 9:45 a.m. here in person in courtroom number 2 at the 34th District Court with Chief Judge Brian Oakley.
Okay. 9:42.
9:45 on December 20th. Sir, are you still on Rosewood?
Yes.
Notice will be mailed to you at that address. December 20th at 9:45. It will be a Wednesday.
Okay.
Thank you, sir. You're free to go.
Okay, thank you.
Have a good day. This is 3S4209776, State of Michigan versus Timothy Bailey. This case was scheduled at 10:45. It's now 1:07 p.m. by the court's clock. Defendant having failed to appear. Matter will be set for show cause. 23L547797 AOT. This was State of Michigan versus Matthew Mark Taylor. This case was scheduled at 9 a.m. for pretrial. It's now 1:08 p.m. by the court's clock. Defendant having failed to appear, matter will be set for show cause. Two, three HR 11466 A and B. These were State of Michigan versus Thomas Ratcho. These cases were scheduled for arraignment pretrial and pre-hearing at 9:30. It's now 1:08 p.m. by this court's clock. Defendant having failed to appear. The civil infraction will be deemed in default. The misdemeanor matter will be set for show cause. These are 23L027393 A and B, State of Michigan versus GFL Environmental. These cases were scheduled at 9:45 this morning. It is now 1:10 p.m. by this court's clock. Defendant having failed to appear, the A file civil infraction will be deemed in default. The A file civil infraction will be deemed in default. The B file misdemeanor will be set for show cause. Yes, please.
Hi, Judge Martin.
Mr. Martin, how are you?
I am good today. Hope you're doing all right.
I am. Where did you start out this morning?
Oh, thanks, Murphy. I was in Judge Prentice Edwards. I was in Judge Nicholas Hathaway, and bouncing in and out of your Zoom room. I think you're
Quite the morning, huh?
just another day.
Just another day. Did you take the Matthews failures to appear, or do those go to Mackenzie? Thank you. This is 230579 FD. Did you need more time? State of Michigan versus Kelly Bluebow. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of 86771.
Good afternoon, Judge Martin. Good afternoon to your staff, neighborhood defender circuits, Carrie Martin, P 84592. Appearing on behalf of Ms. Kelly Bluebow, stands to my right. State your name.
Thank you. Today is the day and time set for the preliminary examination in this matter. There is count one, operating while intoxicated, high BAC, third offense. Count two, operating while intoxicated, third offense. And then count three, misdemeanor, driving while license suspended, revoked, or denied, or let a suspended person operate. Are the people ready to proceed in this matter?
We are, Your Honor.
Defense ready to proceed.
Yes, Your Honor.
Any preliminary matters, Mr. Mohammed?
Yes, Judge, we would like to introduce into evidence under Rule 76611B of the MSP lab report in regards to the 2 vials of blood that were drawn from Miss Kelly Bluebow that came back tested positive for 0.186 grams of alcohol per 100 milliliters of blood in regards to this incident, Judge.
Any response, Mr. Martin?
No objection for exam purposes only.
Thank you. Ms. Bluebow, you may be seated. My apologies. I didn't say so sooner. Any other preliminary matters, Mr. Mohammed?
Nothing from the people.
Any preliminary matters, Mr. Martin?
Nothing.
Your first witness, sir.
Should I publish this?
Yes, please. Thank you.
It's going to be Sergeant Hickman.
Good afternoon, sir. Come straight up to this podium here in the middle, please. State your first and last names and spell them both for the record.
Sergeant Thomas Hickman, THOMAS, HICKMAN.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you much. Come have a seat in this black chair that's closest to me, please. Mary Ann will be recording your testimony. If she's unable to hear you, I'll ask you to either raise your voice or scoot closer to the microphone, okay?
Okay.
Thank you. Mr. Mohammed.
Good afternoon, Sergeant. Can you please state your name for the record?
Sergeant Thomas Hickman.
Sergeant Hickman, are you currently employed?
Yes.
And who's your employer?
Huron Township Police Department.
And in what capacity are you employed?
I'm a patrol sergeant.
And for how many years have you been working at this precinct?
Just under 10 years.
Were you employed in this capacity on August 27th, 2022?
Yes, sir.
Did you work this date?
Yes, sir.
Did you work this date by yourself or with a partner?
By myself.
On this day, were you working in full uniform or modified uniform?
Full uniform.
Were you working on foot patrol or in a scout vehicle?
Scout vehicle.
And was the scout vehicle marked?
Yes, sir.
Can you give a brief description of what that entails?
It had police markings all around the vehicle and it had emergency lights.
And did your duties as a police officer or as a sergeant take you at or near Inkster Road and Bordeaux Road on August 27th, 2022?
Yes, sir.
Is that located in Huron Township?
Yes, sir.
Is this in the county of Wayne?
Yes, sir.
What's at that location? Streets.
Just streets, yeah. I was just on routine patrol.
Okay. And did you observe something at that location that brings you to court today?
Yes, sir.
What did you observe?
A black Ford vehicle.
And what drew your attention to this black Ford vehicle?
Initially, the loud exhaust on the vehicle.
I'm sorry, initially.
The loud exhaust
Thank
on
you.
the vehicle.
And as a result of that drawing your attention, what, if anything, did you do?
I turned around to get behind the vehicle.
Okay. And then what occurred after that?
When we hit the intersection at Inkster and King Road, that vehicle stopped. It would not proceed. The vehicle eventually did proceed forward northbound on Inkster Road. And as I was behind the vehicle's passenger side tires crossed the fog line twice. So that's when I initiated a traffic stop.
So you initiated the traffic stop because the vehicle crossed the fog lines twice? Where are these fog lines located on the street?
They're on the side of the road so you have the middle line is yellow and on the side of on the side of the road, they're white. So they're on the side of the road.
And so just so I understand correctly, they're on the side of the road. Is that like what separates the main street from the sidewalk?
The main street and it could be a sidewalk, could be the ditch, could be anything.
Okay. But so vehicles are supposed to stay in line of the street and not cross that fog line, just to understand, correct?
Correct.
And is it a ticketable offense if they do?
Yes.
Okay. And when somebody is veering off to cross these fog lines, is that indicative of anything based on your experience as a police officer?
Yes, sir.
What is that?
The driver's impaired.
Okay. And so that's just to confirm, that's the reason you initiated the traffic stop?
Correct.
How did you initiate a traffic stop?
I activated my lights.
Did you
My
initiate
emergency
sirens?
lights. Yes.
Okay. Did this vehicle pull over?
Yes.
Okay. And what did you do after the vehicle pulled over, if anything?
I made contact with the driver.
Okay. And was there anyone in that vehicle besides the driver?
No.
And that driver of that vehicle, do you see that person in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that they're wearing?
Right there, a black zip up.
Your Honor, please let the record reflect that the witness, Sergeant Hickman, has identified the defendant.
Yes, sir.
Thank you. And upon making did you make contact with this driver?
Yes.
What, if anything, happened during this initiation of contact?
I requested her information, driver's license, vehicle information, and at that time, she wouldn't look at me. She initially wouldn't answer any questions. I could smell a strong odor of intoxicants coming from her person. I asked her if she had been drinking that night. She wouldn't answer me. She continued to look for her vehicle information. At that time, I told her to just verbally give me her name, and we'll go from there.
And so was she able to produce to you a driver's license?
No.
And is that a ticketable offense?
Yes.
Okay. And she provided you with a name?
Yes.
And did you search that name?
Yes.
And did anything come as a result of that name?
Lean confirmed that she was revoked.
And so you had mentioned earlier that you could smell a strong sense of intoxicant, correct?
Correct.
Do you know what kind of intoxicant that would be? What
Like
it smelled like to you?
a liquor.
Okay. On a scale of 1 to 10, 10 being the strongest odor, what would you rate that? That you smelled in that moment.
I'm going to object to that question. I don't think there's any objective criteria for assessing the strength of a smell, and I just think it's unduly suggestive of, intoxication and unreliable.
Mr. Mohammed?
Judge, he's going to provide an answer based on his perspective on whether the sense of smell of something was strong or not. I mean, we go to the doctor and they say on a scale of 1 to 10, what is your pain level? It's a perspective answer. It's something that an officer is answering based on his perspective. So I believe he's within his rights to answer that question, Judge. Ultimately, respectfully, I'll leave it to you.
I still object.
The objection is sustained. Let's move on, Mr. Mohammed.
Did you notice anything about this individual, this driver, besides the intoxicants that you smelled?
She had red, watery eyes and slurred speech.
Okay. So as a result of that, what, if anything, did you do?
At that time, before I made a second contact with her again, I requested another officer make my location. When they got there, I made a second contact with the driver. I had her exit the vehicle to perform sobriety tests on her.
And did the defendant perform those sobriety tests?
Yes, sir.
What were the sobriety tests?
Horizontal gaze nystagmus, walk and turn, one leg stand, pick the number between 19 and 21, and recite your alphabet starting with D and with Q.
So was that, just to confirm, was that 5 different tests?
Yes.
Okay. And what was the ultimate decision in regards to each test?
Overall or one?
Just go one by one if you can.
Okay. When I was conducting the horizontal gaze nystagmus, I was only able to observe a lack of smooth pursuit. She continued to try to move her head, so I was trying to.
Okay, so you don't have to really delve into exactly what occurred in each one. Did she pass each test? Did she pass,
She passed pick the number.
Of the 5, she passed 1 test?
Correct.
All right. And what is that indicative of, based on your experience as a police officer?
That she's impaired.
Did you observe anything else in the vehicle, on the person?
My partner's located a half-empty shot of Jim Beam in the center console.
Did you observe this?
I did not.
Okay, please don't testify to anything you didn't observe or you didn't recover, okay?
Okay.
Thank you. did you perform a breath test?
I did not.
Did you give the defendant a chemical test rights form, BI 177 form, to answer?
Yes.
And did she, what was the result?
She wouldn't answer yes or no.
And is it true as a result, if someone fails to provide an answer, then it's a no?
Yes.
Okay, what, if anything, did you do after that?
I took her back to the station. I completed a search warrant for blood. I called 34th District Court, got a hold of Judge Green. She authorized the search warrant. And after I got the signed search warrant, we went to Henry Ford Brownstown Hospital. Registered nurse Shannon completed the blood draw with a sealed MSP kit. And once the 2 vials were drawn, we both secured it with an integrity seal. And I transported that and Kelly back to the station. And the secured sealed MSP blood kit was placed in property locker number 35 back at the station.
And this blood draw, did you observe the nurse use this MSP lab report or MSP blood kit?
Yeah.
And do you recall if the wipe that was used was an alcoholic wipe or non-alcoholic wipe?
It was
I'm sorry.
non-alcoholic wipe.
No further questions, guys.
Thank you. Mr. Martin.
Thank you, Judge.
Good afternoon, sir.
Questions for you. So you testified that what caught your attention to this car was a loud exhaust.
Correct.
To confirm, you don't have any specific reading of the volume of that exhaust, no?
No, sir.
You didn't have any sort of device to measure decibels?
No, sir.
But upon hearing this exhaust, you turned your patrol car around and got behind Miss Bluebaugh's car?
Yes, sir.
So you, at that point, you were directly behind her car?
Yes, sir.
And then you say that you saw her not drive on from a stop sign. Is that right?
Yes, sir.
You don't know how long she was at that stop sign?
No, sir.
No. You didn't note any amount of time in your report?
No, sir.
But she did eventually drive on, correct?
Yes, sir.
And then it was after this, you say that she touched the fog line?
Yes, sir.
And I know you talked a little bit about this before, but just tell me again, what is a fog line?
It's the white line that's on the shoulder of the road.
So that would be on the right side?
Correct.
Dividing the lane from the shoulder?
Yes, sir.
So it's not crossing into a different lane across the fog line?
No, sir.
And there are no other cars, at least when you observed it, there were no other cars across the fog line or in the shoulder?
No, sir.
So by doing this, she wasn't coming into the path of any other vehicles or pedestrians?
No, sir.
At this point, you had not activated your dashboard camera?
No, sir.
No. So these things you're describing were not captured?
They should. Our dash cam buffers and it records a prior 30 seconds.
Prior 30 seconds.
So 30 seconds before my stop.
Before you perform the stop. So the dash cam was activated upon you performing the stop, is that right?
Correct.
when you activated your lights, it automatically activated that dash cam
Yes, sir.
and caught the prior 30 seconds. Now, I believe you said that upon seeing her cross the fog line, you initiated the stop.
Yes, sir.
Was there any delay in time between seeing that and starting the stop?
So I guess yes, there was a delay in time when I initially saw her cross the fog line the first time, and I initiated it right after the second time.
Initiated it right after the second time you saw it.
Yes.
Okay. I'd like to show you your dash cam and have you explain a few things about it. And at this point, I plan to approach the witness and Your Honor with video. Mr. Prosecutor, if you would like to join me. And I will be playing the first minute of a video that I will ask Mr. Yes. Ask Sergeant Hickman to identify. So Sergeant Hickman, do you recognize this video?
Yes.
Would you say this is your dashboard camera video from August 28th, 2022?
Yes, sir.
Actually, I believe the date of the offense was August 27th, 2022, which, and do you see here that the video is labeled August 27th?
Yes, sir.
And do you believe this may be an error up here where it says August 28th in the timestamp?
It could be the download date.
The download date.
But yeah, yes.
Okay, but you believe this to be a fair and accurate depiction of the traffic stop?
Yes, sir.
It's blue ball. I will play 1 minute, Mr. Prosecutor, if you want. Yeah, just one. Okay. 0 seconds. And that minute that we just played, that is a fair and accurate depiction of the traffic stop. And that car that's now visible at the 1 minute mark, that is Ms. Blueball's car.
Yes, sir.
I would move to admit this to the record.
Any objection? It's received.
Thank you. So you would agree in that video, when you initiate the stop, when your lights are activated, Ms. Blueball's car is not visible.
Yes, sir.
And in fact, you have to speed up and drive for about 15 or 20 more seconds before her car comes into view.
Yes, sir.
Do you have a policy at your department about use of a dashboard camera?
Yeah, yes, sir.
And does that policy require you to activate your dashboard camera as soon as you see conduct that may justify a stop?
No, sir.
What does the policy say?
I don't believe they turn off, but we can't turn them off, and they automatically activate when we activate our emergency lights.
So the policy does not say that you should affirmatively turn them on at any time prior to activating your emergency lights?
I don't believe so.
I don't believe so. And when did you last review that policy?
We just got a bunch of new policies because we're going through accreditation.
Do you remember prior to this incident, August 27th, 2022, when you had last reviewed or received training on that policy?
I don't.
Objection, Judge. He asked the question of whether he knows, and he said he doesn't know an exact date. That question's been asked and answered.
It was a different question.
Your objection's overruled, Mr. Muhammad. It's a slightly different question. Mr. Hickman, sorry, Sergeant Hickman, you may answer the question.
Yeah, the question just was, and you may not know, but on August 27th, 2022, do you remember when you had last reviewed the dash camera policy of your department?
I do not remember.
So, and it's correct that when you initiated this traffic stop, you had not run the car's plates through Lee.
No,
You
no,
only
sir.
did that later after the stop.
Yes, sir.
And so like we saw with the video, it's fair to say that Ms. Bluebaw's car, when you started that stop, was quite a distance from you, probably 100 yards or more, correct?
Objection, speculation, 100 yards? That's quite.
100 yards is a lot more definite than a 1 to 10 on odor.
Mr. Martin,
Well,
respectfully, your response to his objection.
my response is objection. My apologies. Would be that 100 yards is an amount of distance that anyone, including a layperson, can estimate. I think Sergeant Hickman is fully capable of estimating whether at the point when he initiated that traffic stop, Ms. Bluebaw's car was 100 yards or more from him.
Anything else?
Yes, Judge, and how would that be any different from him saying on the scale of 1 to 10, how much a person's, the smell of odor to him is different in this situation in regards to estimating distance of 100 yards, the size of like a football field? I mean, I'm objecting, Judge.
Your objection is overruled. Sergeant Hickman, you may answer the question, the distance from your car to Ms. Bluebaugh at the time that you initiated the stop. If you recall.
You would say over 100 yards? Is that your question?
Would you estimate that it's 100 yards, if not more?
I don't feel comfortable saying yes or no.
All right. But you were initially right behind him, that's right?
Yes, yes, sir.
And this, you had a hunch that the driver was drunk?
Yes, sir.
And even though you believe this driver may have been drunk, and they were once right in front of you, something happened that their car got quite a bit further in front of you and other cars got between.
Yes, sir.
In your report, I mean, you never observed the car speeding.
No, sir.
No. And you said crossing the fog line, but you never stated in your report that the car was swerving or weaving.
No, sir.
And do you recall whether there were potholes on that road?
I don't recall.
Don't recall. But you were working alone, as you said.
Yes, sir.
There's no other officer who could confirm your observations about.
No, no, sir.
Okay, I have nothing further.
Thank you. Any redirect, Mr. Mohammed?
Based on that last question, there was no officers with you, but was there any officers that responded after?
Yes, sir.
Oh, just confirming. What's the name of that officer or officers, if you recall?
Officer Lalovich and Officer Jolly.
Okay. And you had mentioned earlier, or defense counsel has mentioned earlier that you had a hunch that the driver was drunk, correct? What was that hunch based on?
The fog line,
Okay,
the vehicle passing the fog line.
and just to confirm, it happened twice, correct?
Yes, sir.
Now, as far as the camera sees directly in front of you, correct?
Yes, sir.
But it wouldn't see something, and then, and in that video that was played, there was a vehicle directly in front of you, correct?
Yes, sir.
And so you could see something that the camera doesn't catch.
Yes, sir.
And you had mentioned earlier that there's delays, right? It's when you turn on your lights, correct?
Yes, sir.
So you could have witnessed something and then turned on your lights, which would have then started the recording, correct?
Yes, sir.
Was there any statements by the defendant that was made to you?
Yes, sir.
And what were the statements?
When we were in booking, she advised me that I don't know what it's like to go through addiction, and that this was going to be her fifth drunk driving offense.
Okay, no further questions.
Thank you.
One last question, Sergeant Hickman. You confirmed that the video that we showed, which is from the beginning of your dash cam recording that day, does not depict crossing the fog line.
The video does not show that?
You would agree it does not show that.
Yes, sir.
And you also agree it does not show this apparent stopping too long at a stop sign.
Yes, sir.
Okay.
Anything else, Mr. Mohammed?
And just to confirm, but your testimony today is that you did observe with your eyes both of those incidents, correct?
Yes, sir.
Thank you.
Thank you. Sergeant Hickman, thank you for your testimony, sir. You may step down.
Thank you, Your Honor.
Your next witness, Mr. Mohammed.
The people called Officer Lalovich.
You're welcome. Good afternoon. Would you state your first and last name and then spell them both for the record?
Adrian Lalovich, ADRIAN, LJALJEVIC.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you much. Come have a seat, please, in this black chair that's closest to me. Mary Ann will be recording your testimony. If she's unable to hear you, I'll ask you to either keep your voice up or move closer to the microphone, okay?
Okay. Your Honor, before Officer Lalovich testifies, I would ask for the sequestration of witnesses. I know that Sergeant Hickman is the OIC, but he's also the primary witness in this case. And in case there's any future testimony collected in this case after today, I'm concerned that the Officer Hickman sitting here and listening to Officer Lalovich's testimony may taint his ability to testify purely through his own observations.
Mr. Mohammed?
you would like me to step out, I have no objection.
Sergeant Hickman, thank you.
Good afternoon, officer.
Good afternoon.
Can you please state your name for the record?
Officer Adrian Malovich.
Officer Lalovich, are you currently employed?
I am.
Who's your employer?
Huron Township Police.
And in what capacity are you employed in?
I'm a police officer.
Were you employed in this capacity as a police officer on August 27th, 2022?
I was.
Did your duties as a police officer take you at or near the street of Inkster Road and Brideau Road?
They did.
Is that located in Huron Township, County of Wayne?
It is.
And what, if anything, took you to this location?
Sergeant Hickman had conducted a traffic stop and had called out over the radio that he was conducting an OWI investigation. I had then drove over to, correction, my partner drove us both to the scene to assist him on the traffic stop.
And what were your duties as a result of assisting?
I observed some of the sobrieties that Sergeant Hickman was conducting, more of as an officer safety thing and be a lookout for traffic. At the conclusion of the investigation, when he had made the arrest, I conducted an inventory search on the suspect's vehicle.
And upon doing this inventory search, did you recover anything?
I did. Inside the center console of the vehicle were two full shooters, approximately 100 milliliters. One was Jim Beam that was full. The other one was a Fireball shooter that was full. And then I also recovered one shooter, 100 milliliters of Fireball that was half empty.
Okay, and just from my understanding, because I don't drink, so I'm not really familiar, are these alcoholic beverages?
They are, they're liquor.
Okay. And that individual that was arrested on that day, the driver of the vehicle, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that they're wearing?
It'd be the woman right here wearing a black top.
Your Honor, please let the record reflect that the witness has identified the defendant, and I have no more questions. Thank you.
Thank you. Mr. Martin.
Officer Lalovich, you were not present for the initial traffic stop.
No, I was not.
And you did not observe any of the driving prior to that.
I did not.
I mean,
Thank you. Anything else, Mr. Mohammed?
Nothing for the people, Judge.
Officer Lalovich, thank you for your testimony this afternoon. You may step down.
Thank you.
Your next witness, Mr. Mohammed.
No more witnesses.
Any witnesses, Mr. Martin?
None from the defense.
Argument, Mr. Mohammed.
Judge, the people moved to bind over on all counts, and I reserve arguments.
Thank you, Mr. Martin.
Judge, I have a few things to say about this case, and we are objecting to bind over because the traffic stop, there was no probable cause to stop Ms. Blubaugh when it occurred. First of all, we have a video that was admitted into evidence that Your Honor and Mr. Prosecutor and myself watched, which shows that when the lights were activated, the car was a considerable distance. The officer, Sergeant Hickman's patrol car was a considerable distance behind Ms. Blubaugh's car. He wouldn't give an estimate of exactly how far, but in the video we saw it took 15 or 20 seconds of him passing another car, speeding up to get behind Ms. Blubaugh's car. And this was right after Sergeant Hickman had testified that he initiated the stop immediately after seeing Ms. Blubaugh's car cross the fog line. It is the duty of Your Honor to assess witness credibility at this stage. That includes officer credibility. And we've admitted into the record video that completely contradicts and undermines the claim of Sergeant Hickman about his basis for the stop. These reasons, indicia, he says contributed to him making the stop about crossing the fog line and stopping an indeterminate amount of time at a stop sign are not depicted anywhere. and he had no other officer with him. We have nothing more than his word, which seems to be directly contradicted by the video evidence. But even if we take Sergeant Hickman at face value, that he did observe crossing the fog line, he did observe stopping too long at a stop sign, this still does not create probable cause to justify a stop. He didn't observe traffic infractions. This is not speeding, this is not swerving, this is not failure to signal. This is an indeterminately long stop at a stopping sign. There's no testimony that that impeded traffic. And this is touching a fog line. It's not swerving into another lane. And in fact, there's precedent from Michigan courts and courts of other states that says it's not illegal to touch or cross a fog line. For example, from here in Michigan Court of Appeals, a 27 decision called People versus Kosovar that found that the momentary crossing into the fog line does not amount to a violation of MCL 257-642, part of the traffic code, finding a traffic stop that was justified for that reason to be invalid. There's no impeding traffic. What is described sounds more like slow and cautious nighttime driving. There's plenty of reasons why someone might hug the right fog lane of a single lane, of a two-lane road at night, whether it be potholes, whether it be avoiding oncoming traffic that have nothing to do with the driver's sobriety. We heard Sergeant Hickman himself say that what he had was a hunch. As you well know, a hunch is not probable cause.
I'm gonna object, Judge. That's the sergeant never said he had a hunch. That was Mr. Counsel who said that.
Well, he agreed.
But you just said that he said that.
Mr. Mohammed.
I'm just going to say, I asked Sergeant Hickman if he had a hunch, and he said yes. That's all.
Thank you. Mr. Mohammed.
Sure. Judge, Mr. Martin mentioned that there was a hunch in regards to the officer. That hunch in this situation is called reasonable suspicion. This officer, what he observed was an individual who was stopped at an intersection and didn't move right away. Maybe they were impaired. You know, their perception's a little different when you're under the influence. Further, the sergeant testified that he observed this vehicle cross these fog lines not once but twice. Further showing that, you know, there's potential of impairment. The officer testified that it's a ticketable offense to do that. So reasonable suspicion definitely exists. And in regard to the camera, there's a vehicle directly in front of the police officer's camera. There's a vehicle directly in front. And so maybe it's not capturing what's in front of it. It's also only capturing directly what's in front. It could have been, you know, a little bit of a distance. The officer testified that his attention was initially drawn due to the loud noise that the car was emitting. So even though he was behind a vehicle, that loud noise may have been still catching his attention. So he's observing this vehicle, and he observed it from his testimony across that fog line twice. So the people believe that we've met our burden of probable cause. You know, the MSP lab report shows that she is over the required number required to meet these elements. Her own statement, the defendant's own statement, is this is my 5th OWI, you know? So she's already admitting guilt and she knows what she did. So Judge, in regard to the probable cause standard, the people move to find it on all counts. Thank you.
Very briefly, what's at issue here is the legality of the stop. And she cannot be bound over on evidence that was seized in violation of her Fourth Amendment rights, which this was. This was a traffic stop not supported by probable cause. And there's serious credibility issues with this officer who appears to be providing uncorroborated post hoc justifications for a stop. I object to bind over.
And Judge, just in response briefly, you know, this sergeant whose testimony today was provided was that not once did he see the fog line, but twice. And not just that, the reaction to move from a stopped intersection, like failing to move. I mean, this impairment, it's raising suspicion. And it wasn't that alone, but the totality of the circumstances. That plus the fog line, not once, but twice, that drew his suspicion. Reasonable suspicion did occur here. He initiated a traffic stop and he confirmed that suspicion. He performed field tests. There's no question that the individual is under the influence and the stop is reasonable. Thank you.
The court did have the opportunity to hear the testimony of both Sergeant Hickman and Officer Lalovich this afternoon and will bind Ms. Blubaugh over as charged. The court is finding that the testimony of Sergeant Hickman was that he has been 10 years as a police officer with Huron Township Department of Public Safety, that he initially was attracted to or directed to Ms. Blubaugh's vehicle by virtue of the noise that it was emitting, that he then observed her to cross the fog line twice and then stop at a stop sign for an inordinate amount of time. My word, not his, inordinate. But he, based on his experience, believed that Ms. Blubaugh might be under the intoxicated, and the rest of the investigation unfolded from there. For purposes of exam, the court will find that that was sufficient for the probable cause standard. Ms. Blubaugh, your next appearance date will be at the Frank Murphy Hall of Justice on December 20th, 2023 at 9 a.m. Your previously entered bond with any of its conditions will continue. Mr. Mohammed, is there anything else? Mr. Martin, is there anything else?
Nothing, Judge. Thank you.
Thank you. That concludes this matter. Ms. Blubaugh, good luck to you.
Thank you.
You're welcome, ma'am.
Appreciate your insight.
Mr. Mohammed, did you need your lab report back?
You can keep it.
I was gonna say Mary Ann can make a copy.
No, I don't need it.
You don't need it, okay.
Thank you.
So. 2 o'clock. Have we, oh, no.
Okay.
What's wrong?
Hamilton
Yes.
is either going to be very, very late.
I thought Blaze Kearney was coming for her.
He's not coming, is he?
I don't know.
I thought he was gonna be on Zoom.
I don't know if Blaze is gonna be on Zoom. I know that the prosecutor.
Well, they said that may be a dismissal also.
The 2:30.
Yeah.
Well, I thought they were gonna be.
Okay.
Well, either she's going to be very, very late or she's gonna send somebody.
Okay. So
Do we want to do the other one?
there is no other one.
What about the 2:30?
That's Blaze. Vanessa Hamilton is 2. Blaze Kearney is 2:30.
What about 1:30?
Oh, I thought, wait. Oh,
Got an update for you?
wait.
So, Mr. Balaz walked in. And Mr. Balaz is here. He said he's covering for Vanessa Hamilton on Jones.
Uh-huh.
He also said, maybe Mary Ann, I don't know if you know this or not, but Morris, last one is to be a dismissal. Is it officially dismissed?
Patricia said it was gonna be a waiver, but she's coming on Zoom.
The 130 with Christian Harris and Mr. Carey.
Mr. Harris is here. All parties for Harris are here. But Jones, the word now is.
That was the indication this morning, so.
Okay, I didn't know. I just was told by her client, he just walked up, Mr. Jones told me Vanessa's not gonna make it. She's gonna have to either be here late or someone step in. So that's where we're at with it.
Okay. If somebody has a minute, those need to go down to Mackenzie for me, please, and thank you.
What's that? I'll hide it.
Yeah.
We had 3 different stories on cases. Oh, if this attorney wasn't coming, this one's gonna play, this one's here.
Yeah, so one of them, I don't know if she's gonna show up. The author diversion. We were almost gonna dismiss the case too. Just didn't want to go. Crazy.
Well, we'll see.
What was that? Oh. So, hi, morning. So with this case, I'm really disappointed how this case was. Like Vanessa. The reason is, I went above and beyond to get the version. I read the facts of this case, of this guy, lost his job, let me do something. You know? We're not supposed to go and try and fight for that version. That's supposed to come from the defense attorney. You guys did that, but I did that. Okay, I reached out to her, and she just didn't want to answer my call. I tried to like 3 or 4 days trying to get in touch with her, and I did let me know it's gonna expire by tomorrow. You know, I gave a whole day, then the next day she just didn't want to answer. That's not cool, right? I'm going to just send you a stipulated order. She said this case should be either adjourned or dismissed. That's what she sent me in an email. And she read out the facts of the case, and she said basically the facts of these things, but you returned them, let's just dismiss it. I'm sorry, that's not how it works. She basically admitted to the crime in the email. Okay. You know, understand. I'm talking to you, trying to make sure you're right. This case could have been dismissed. Let me tell you why. Because they called me and they wanted to get in touch with her, and they wanted me to, you know, see if we can do it. Okay? I was gonna adjourn her. I'm calling her, I'm calling Carrie, someone to get in touch with me. She's not answering. So because of that, these people are coming here today. People from the airport are here, attorneys from the airport are here, so we're gonna have the exam. And it's so not cool. Now this defendant could have had his case dismissed, could have had, you know, diversion, you know, and now what's gonna happen? Is that good representation for the client? Is that NDS policy to, you know, let's not answer the prosecutor's law? Like, come on. So we said you would like to have an earnest, you know, try to get the case dismissed. You said no. I was no, please. No, so when you said you could get it dismissed. let's kind of get it adjourned. And in this statute, Dr. I was kind of reaching out, like, let me see if I can do that. You know, I reached out to her and then, you know, there was no answer. And I want you to understand how much I want to take. I sent multiple emails, marked them priority. I called her, like, I haven't called 5 times. I reached out to her, period. It's in the best interest of the client. Please have her call me.
So are you saying you want to adjourn this a few days ago?
I wanted to, and that's because of, they said, let's adjourn it, and we can talk about the lawsuit, and see if we don't go any forward. Right? But when they found out that she's not adjourning, they're like, you know what? We want to do, we're gonna show up. And I did everything I can, because I don't want the guy to have to deal with it. So I just feel like there's this lesson in a sense, as far as being fired. But then also the fact that he's making me think, you know, he's bragging about stealing, right? He's not really just stealing it. There's no remorse. I'm not. It's one thing if you make a mistake. We all do. I make them. We all do. But you're sitting there bragging about it. It's just, I don't know. I don't know where I'm at with the case. If you seem like a really cool, nice guy, and so I'm thinking about so often that we're going to, even though it did expire, and the only reason is that you were Vanessa, I wouldn't have called. I think it's fair for this guy to get this chance still, regardless of his dreams of the state. So it's kind of a judgment call. So I'll give you, you know, a few minutes to think about it. The deal is, if there's a waiver, it's diversion to the food. But it requires a waiver, and so if that's the route you want to go, cool. This is not going to be this way. I came in today, I prepared out my notes for a whole. But just for the record, that is so not good. That's like not going to be good. You know, why do people, I mean, I'm not saying you have people, but why do some people just like move for like that? You know? We're all just trying to help and make society better. You guys as well as us, but why not? It makes me unhappy. You know? Is a turn?
this is, we're ready for Morris, dismissal. No. We're ready, we're excuse me. Yeah, version was only offered, the only reason I love it. Your honesty, well, we take the constitution, this is ultimate. So him and it was honest, but that yeah, it's like at my house, you know, that's why I was like, I want to help this guy. So he was honest at that. So let me go. We don't go to that. We don't ask ever that comes from the night. They go to the. And I said, I went up and I'm like, look, this situation right here, this guy needs to be helped. Because he was honest at the end of the day. He did admit to taking it. He did admit to having it. So let's help. No, there was no serious damage that happened to the airport. They eventually got it and they sold it. At the end of the day, crime was committed. He did commit the crime. He admitted to the crime. That's why I was like, let me get that. And last thing. So for me to go above and beyond, and I really did, I promise you, I give you my word, I'm above and beyond and help this guy forever. And to just be disregarded for a few days, like, that's not cool. And that's why there was no more diversion. And if it wasn't today, there should probably be more diversion. One, but that's not what I'm making that decision. It wasn't, well, how am I making that decision? Who said that? No, I'm saying I'm re-offering the diversion you said if it wasn't easy. I wouldn't, which is definition of it. It has to be the attorney who's been appointed the case, who's referred you to the discovery, who's worked with the client, who's making the decision about whether to wait or not. I'm not saying that it would be a bad decision to accept diversion, but we can't do it. And because Vanessa's in a 1:30 exam at 36, which is a perfectly valid, we know what our schedules are like. We request adjournments because we're up for all the time. It's not me. So, I mean, I just want to do this. And that's why the offer, it had nothing to do, I don't know that that's not it. I don't even know. I think you said this is not professional, you said that like this, you don't treat your, yes, it's not good. I know, not for me, for the client. It's not, you're not doing this. It's really not your business, the relationship between defense counsel and client. So that's all I'm saying. But would you say this as in like? So just so we understand. No, the actual, I had this situation on hold. Here's where, and I'm saying you have negative media comments where they put something in writing that folks in survey board have later on said this. And I lost it. It's something that's in writing on the record that would be step one. And I'm happy to do that paper. Okay, so how about this? How about one, I show you the diversion that those you can be the witness. I'm sure you said. No, in our proposal, they don't have that. Two, I'll mention our one. And three, I will
maybe this is just a little like, and I will take your word for it, and maybe she just didn't have the opportunity. And so what I will say on the record is that we will adjourn for a future date. And it's under the understanding that you're gonna overlook whether ever.
Yeah, well, I think if we just.
Also, you want this, we just want to talk today.
I want to talk to her. If she says go in there and get the exam, that's what I'm, if she says they're offering to consider there, weigh the exam, get it, that's what I think. Better position. I'm gonna bring you, Steve. You might not know it. All right.
The version was only an option in this situation because I wanted to find it and get it for this person. You do understand that, right? Like, it wasn't in the notes he offered it. It was this is a rule normally, but because he,
When you go out and look for offers, that's great. That's great prosecution. Should we go for Christian Harris? He's right out there. I'm ready to go.
You want to thumb wrestle? That might be quicker.
Russell?
I said thumb wrestle. I didn't say
Thumb
wrestle, wrestle.
Oh, and then, Mr. Carney has a case as well. I'm not sure. I'll go grab it.
Thank you, Mr. Merton. Uh-huh. So you hadn't seen this before.
No, you make me smile, and I appreciate it.
That's why it's still out here.
Is it like a little acorn?
It's candy corn.
It's a candy corn.
It was perfect for Halloween, but now it's kind of like,
Who made that?
I got it at Apple Fest. Listen, you have this huge expanse and you have to do something. You have to zhuzh it a little bit.
I think that the prosecutor just standing next to him.
She's not.
She said she was in the waiting room. I texted her. Is she in the wrong waiting room?
Give me 1 second. Mary Ann is still. She's not here. I'm host. She's not here. How are you? I know. I've seen you on Zoom, but you refuse to come out here anymore. You're doing homicides and whatnot.
I find myself in Westland as the district court that I haunt. This is much harder to convince our lawyers to go out there than it is here.
Westland.
This is by far the most popular district court of the 3 district courts that we.
Because we're entertaining, if nothing else.
I think there's a fair amount of like things move, things are reasonable. It's people
You're
enjoy their experiences. out
Westland, Romulus, and where else?
here. Taylor.
It's definitely the most.
Taylor's number 2 is, Westland is tough.
Westland, their building remodel was one of the best uses of an existing building, I think.
Where did that used to be?
It used to just be the narrow part, that part in the front where you go through security with that big, that's new. Well, it's new to me, but it's newer.
It's nice.
They did, yeah, they just expanded their building versus building a new one, but Taylor, their building is fantastic. They used to be in that super dark, it looked like an old schoolhouse that's just next door, just east of it.
Carrie never got to see the old 36 district court.
I never saw old 36.
Old
I did
36.
see Old 34.
Before CCS came and zhuzhed it up,
Yeah.
36 was, oh my gosh.
Were you ever in the old 34th district?
Once or twice, I did court production units.
Really?
It was just a program where we would watch bond hearings and take notes about it, collect statistics and stuff like that. So I came out, I think on a Saturday to.
Well, you watched arraignments then.
Yep.
Oh, yeah.
Yes, it was the weekend arraignments for the whole.
the carpet that was older than some of the attorneys. Some of the carpet was the original carpet.
What was the courthouse? 'Cause it had a big like middle school library vibe in there.
It's always a courthouse.
Huh.
That started off one way, they kept adding on to it, making it longer, but this is just leaps and bounds beyond what it
Oh,
was
yeah.
originally.
I asked Judge Oakley what orphans fund got robbed to build this building or something.
But Rochester did the same thing. They were in an old, had you been out to Rochester before they built the
Oh,
new
no, no,
building?
no, I've seen it.
It was kind of like ours, except it was a long, narrow building and it was with other professional, like medical offices and things. It was super tight. So when they built the humongous thing, I mean, I love their courthouse, but it was such a big difference between that one story narrow, had to squeeze by people to get through security kind of thing to the two-story magnificence that they have now.
There's still some of the really outmoded ones. Garden City has a very older run.
You don't like being in council chambers for your hearings?
Huh?
Council chambers, that's
Oh,
what
yeah.
that is.
Oh, yeah, it's that.
Ipsy's the same way, where you walk right in and go down the slope to get to the front.
Hamtramck is it's a trip.
Ooh, Pontiac.
I've never been to Pontiac.
Are you serious?
The circuit court, I've never been to Oakland Circuit
I'm
Court.
talking about district
Oh,
court.
the district court, I've never been there.
Years and years ago, there was something wrong with their AC, and I knew there was a problem because as I walked up to the front doors were propped open. The courtroom doors were propped open, and Judge Thomas, his robe was unzipped, and first thing he said was, "Excuse me, but our air is not working." And they had fabric on the walls and fabric seats. It was,
Oh, man.
no, Miss Mandernack, I keep watching for her.
Should I text her a particular Zoom number or something?
It's the same one she was on this morning.
They say they don't see you.
I was being really at this job, and my client was unsure if he had showed up to Frank North Route 36. All I could think to say was, is it really well lit or is it dimly lit?
I actually, the other day, I was just watching a judge impose fines and costs, at the end of the sentencing. And with Judge Slavens and his spiel is, this is $1,300 is for the cost and maintenance of processing a case in this courthouse. And I thought, what maintenance? What maintenance? I've been looking around here, Franklin, I haven't seen any maintenance.
Can't say that. Usually just kind of, right? All those court costs are going straight.
Are you breaking our nice stuff? Okay.
You gotta do it, right?
Yeah, I really wish we could do trials in the courtroom.
Why don't you? You're more than welcome to, here she is. I haven't been to Frank Murphy since I had jury duty down there 8 years ago, 9 years ago, something like that.
It's only, the only difference is fewer elevators work now.
There's one in 36 was cranked in Judge Garrett's court.
Oh, because all their courtrooms are
Yeah.
built for prelims, not for jury trials. They should have a good jury trial court. Because the building's nice and like, honestly.
When you only get 6 jurors.
Prosecutors.
And puppets. Senior, the musicals. Canastas. What, the one with the lipstick on the. Oh. It's, what, in the grand scheme of things, it's fine. Thanks, Fred. It's twice every 6 weeks. If you all can't behave, go in the back, please. Behave or be absent. How about that? Ms. Mandernack?
Yes, Judge.
This is Mr. Kearney, Mr. Morris, Miss Morris, my apologies, Miss Morris. Oh, yes, thank you. 230758 FY, State of Michigan versus Morris. May I have your appearances, please?
Good afternoon, Your Honor. Patricia Mandernack for the people, P 84088.
Blake Crane from the Neighborhood Defender Service of Detroit, P83960 on behalf of Ms. Morris, who joins me in person today.
That's Sean Morris.
Good afternoon, Ms. Morris. How are you?
I'm good.
Good. Today is the day and time set for the preliminary examination in this matter. There is count 1, assault with dangerous weapon, count 2, felony firearm. Are the people prepared to proceed?
Your Honor, at this time, the complaining witness contacted me. He indicated he is unwilling to cooperate with prosecution. I am unable to proceed without him.
I would therefore move to dismiss, Judge.
Defense motion to dismiss is granted. This case is dismissed without prejudice. Is there anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
I'm going to ask that the court sign an order for return of property for Ms. Morris that was seized during the course of this investigation. Would the court be willing to sign that order of return of property?
We don't typically when the case is dismissed as sufficient. If you have an order proposed, I'm not
I'll do
opposed to
that.
signing
It's a
it.
firearm that sometimes people will get antsy about
Okay.
returning and not returning, and Ms. Morris does have a CPL, so it's,
If you present it, the court will sign it.
I'll do it. I'll email it.
To Mary Ann? Anything else? Thank you. Good luck to you, ma'am.
Thank you, Judge.
Thank you, ma'am. So what did he do to get it going? Do you know?
You don't tell him.
Oh, so yeah. Books. Well, because they've been over here.
Christian Harris.
Thank you, Mr. Martin. This is 230773 FY, State of Michigan versus. You said it and I called the wrong case anyway, Mr. Martin. Let's try again. 230752 FY, State of Michigan versus Christian Harris. May I have your appearances, please?
Christian Harris. Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
And good afternoon, Judge Martin. Good afternoon to your staff, Neighborhood Defender Service, Carrie Martin, P84502. On behalf of Mr. Christian Harris, who stands to my right, and stated his name already.
Thank you. Today is the day and time set for the preliminary examination. There is count 1, delivery and manufacturing of a narcotic or cocaine less than 50 grams. There is a count 2 misdemeanor, driving while license suspended, revoked, or denied. Are the people prepared to proceed this afternoon?
You are, Your Honor.
Defense prepared to proceed.
We are.
Any preliminary matters, Mr. Mohammed?
If I may just run and grab the MSP lab report, Judge.
Yes, sir.
Thank you.
You may be seated, sir. Oh. Are you saying you've never seen it?
No.
It's been up here all year.
It is kind of handy.
Well, because it has our, whatever on it, our dates.
Judge, I'd like to, as a preliminary matter, introduce the active MSP lab report under the Rule 76611B, which will show that 56 blue round tablets M30 were tested by MSP lab and came back positive for fentanyl. And these are the drugs that were recovered from Mr. Christian Harris.
Thank you. It will be received.
No objection for exam purposes only.
Understood, Mr. Martin. Any other preliminary matters, Mr. Mohammed?
Nothing.
Any preliminary matters, Mr. Martin?
Briefly, I just note for the record, first, that this case is refiled. It was previously dismissed. I'd also note for the record that on the refile, there is a spelling error in my client's name. It's spelled as Chrisitan instead of Christian. And I'd just also like to note the discovery previously was dismissed in part because of lack of discovery. And I was satisfied to proceed to exam, but the discovery is very minimal. And I will note that there is no body camera of only a dash camera. So there's nothing directly depicting interior of the car that you may be about to hear about, or Mr. Harris's actions on that day. Just noting for the record.
Thank you. And Mr. Martin, it was my belief and understanding that we fixed the spelling of Mr. Harris's name back on October 18, 2023.
Great.
If it's not showing on the ROA, it's showing on the court's ROA, and it is showing on the court's file.
Very well.
Anything else, Mr. Martin?
Nothing.
And Judge, just for the record, my understanding was that it was previously dismissed because the MSP lab report was in, just for the record.
Is that pertinent to
I'm just saying.
your first witness, sir?
Officer Adam.
Thank you. Good afternoon, sir.
Good afternoon, Your Honor.
Would you come all the way up to this podium in the middle for me, please? State your first and last name and then spell them both for the record.
First name Chad, Chad, last name Adam, Adam.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you much. Please come have a seat in this chair that's closest to me. Mary Ann is recording your testimony. If she's unable to hear you, I'll ask you to either raise your voice or pull the microphone closer. I'm sorry, Mr. Mohammed, before you began. Mr. Martin, I'm not sure how this is possible because we've been here now 3 times. It does not appear that your client was ever arraigned in this matter, just as a logistical, technical matter.
That is surprising, but we will go ahead and arraign him now. We would waive the formal reading of the warrant, stand mute to the charges.
Thank
Ask for
you.
a personal bond.
It says held, but it was out county hold, so it's not noted in the court file. That was more technical clarification. Anything else? Mr. Mohammed? Yes, please.
Officer Adam, can you please state your name for the record?
Officer Chad Adam.
Are you currently employed, Mr. Adam?
I am.
And who's your employer?
City of Belleville.
I'm sorry, can you speak up?
The city of Belleville,
And in what capacity are you employed there?
police officer,
And for how long have you been a police officer?
total of 5 years.
Were you employed in this capacity on May 5th, 2021?
I was.
Did you work this day?
I did.
Did you work this day by yourself or with a partner?
I had a partner,
What's the name of your partner?
Ashley Rosignol,
On this day, were you in full uniform or modified uniform?
full uniform,
Were you on foot patrol or in a scout car?
scout car,
Was this scout car marked or semi-marked?
fully marked.
Fully marked. Can you give a brief description of what that entails?
It's a white Ford Explorer with the insignia of Belleville Police on the side, overhead lights, push bar.
And on May 5th, 2021, did your duties as a police officer take you at or near North Liberty and 3rd Street?
They did.
Is that in the city of Belleville?
It is.
Is that in the county of Wayne?
It is.
And what, if anything, did you observe at that location that brings you into court today?
Observed a vehicle traveling at a high rate of speed. Radar unit showed 45 miles an hour in a posted 30-mile-an-hour zone. I pulled up behind the vehicle. I watched the vehicle go down North Liberty Street, high rate of speed, disregarded the stop sign, and come to rest after I activated my overhead lights at 3rd Street near Liberty Street.
And so initially you saw the 45 and the 30 with a radar, you said?
Yes, sir.
Okay. And then it was after that that you observed the running the stop signs? Was that stop signs you said?
He made a left-hand turn and then disregarded a stop sign.
Okay. And when you initiated a stop, how did you do so?
With my overhead lights.
And did you use sirens?
I did not.
Did the vehicle pull over when you initiated lights?
It did.
And what did you do as a result of that?
I approached the vehicle, advised the driver the reason for the stop, and requested pertinent information to identify him in the vehicle.
Okay, and the driver of the vehicle, do you see him in the courtroom today?
I do.
Can you please point to him and point out an article of clothing that they're wearing?
He's behind you in the checkered shirt.
Your Honor, please let the record reflect that the witness has identified the defendant.
Yes, sir.
Thank you. And was there anyone else in the vehicle?
There was a passenger,
Okay, where was this passenger sitting?
the front passenger seat.
Okay. And this individual you identified earlier, just to confirm, was the driver of the vehicle?
The individual I identified, yes, was the driver.
Yep. And did he produce a driver's license?
He did not.
As a result of that, what, if anything, did you do?
I requested that he step out of the vehicle. He was acting pretty nervous. I requested he step out of the vehicle and he was detained for no operators on person.
Was there any reason why he didn't have a driver's license?
His license was actually suspended and he had a warrant with us for the same.
How did you confirm that?
Through LEAN, Law Enforcement Information Network.
So he had warrants out for his arrest?
He did with Belleville.
So as a result of knowing that information, what, if anything, did you do?
Detained him in double locked cuffs to the rear, placed him in the rear seat of my vehicle and identified him through a Myers image as Mr. Harris.
And you confirmed he was the person who had active warrants?
I did.
And what happened after that?
We conducted an inventory search of the vehicle.
Why did you perform an inventory search?
The vehicle was going to be impounded because no one was able to drive it.
Why was it going to be impounded?
Because Mr. Harris was suspended.
Is that a ticketable offense?
It's a misdemeanor. It's an arrestable offense.
Okay. And upon performing this inventory search, did you observe anything being recovered?
Yes, we recovered an amber colored prescription vial with no name on it, with several pills later identified as 56 of them.
Okay. Where did you recover these 56 pills?
In the center armrest console of the vehicle between the driver and the passenger seat.
And do you recall the color of these pills?
They were blue.
Okay. And do you recall any inscription on these pills?
It had the letter M in a block and it had the number 30 on the back.
And when you saw these pills, did it bring your attention to anything specific, or were they just regular pills?
It did. I recalled a bulletin, police bulletin from, I believe it was Evansville, Indiana.
Your
I'm
Honor,
sorry, I
I'm
can't
gonna
hear you.
object to Officer Adam testifying to any contents of a bulletin that he read as a hearsay statement.
How is the officer observed the bulletin with the same pills as something? How is that hearsay? That's not a statement by anyone. It's an image, I'm assuming. That's not a statement.
Well, anything written in the bulletin that he's trying to repeat now would be an out-of-court statement admitted for its truth.
Objection
the definition.
sustained. Let's move on, Mr. Mohammed.
Okay, and these pills that were recovered, what, if anything, did you do with them?
They were entered into evidence because there was no name on the vial. So we had arrested Mr. Harris for possession of analog pills because there was no name on that prescription vial. And we entered them into evidence to be further analyzed by Michigan State Police.
Did you recover anything else on that day?
At the jail, we recovered a scale on Mr. Harris's person, as well as $2,700 in cash.
And based on your training and experience as a police officer, what is carrying a scale with $2,700 indicative of?
It's indicative of drug sales.
And where was this recovered?
It was on his pants pocket, in his pants pocket.
The scale was in his pocket?
The scale was in one pocket and the cash was in the other.
Do you recall the shape of these pills?
They were round.
Were you suspicious of anything in regards to these pills, what they were?
I believed through prior knowledge that they may contain fentanyl.
What was your knowledge based on?
My knowledge was based on an informational email chain.
Again, I'm gonna object to, he's about to talk about things stated in an email chain. It's an out of court statement that he's using to justify his conclusion that these pills contain fentanyl. Oh, that's a question.
Thank you.
Did the pills that you recovered that day, did they, or you observed your partner recover and you took into your possession, did you observe any kind of a drug that looked like that before? That was circle blue and had 56 on it?
I have.
And what was the drug that was associated with what you recall seeing?
I believe it would be OxyContin, but I'd have to refresh my recollection.
Okay. No further questions to this witness, Judge.
Thank you. Mr. Martin?
Afternoon.
So first off, the car that you stopped, Mr. Harris was not the registered owner of that car, correct?
Correct.
He was not the only occupant of that car.
Correct.
You found that the car was registered to a different individual by the name of Rajun Dell II.
Objection, assuming facts not in evidence.
It's in the report. I'm just at, maybe I can rephrase. You ran the car through lien.
Correct.
You found a different registered owner.
Correct.
And if I told you that owner's name was Rajun Dell II, does that sound correct?
I believe that may be correct.
Okay. Mr. Dell, the registered owner, was not present in the car.
Correct.
So your understanding was that the driver, Mr. Harris, had borrowed the car from a friend?
Correct.
In fact, he stated that to you?
I believe so.
He stated that he was hanging out with friends and had driven his friend's car to the store to get juice?
Correct.
There is nothing specific that you observed that would suggest that Mr. Harris had been using this car for a long time.
I can't assume that.
So, from the inventory search, there were no items that clearly belonged to Mr. Harris or mail addressed to him or other items like that would.
Nothing that said his name on it.
Nothing that said his name. Now, you just testified that this pill bottle, so it was your partner who recovered the pill bottle?
She advised me of it and I stepped up to the vehicle.
Okay, your partner advised you of recovering the pill bottle. So when you stepped up, where was the pill bottle when you first saw it?
I believe it was in the center console.
I see, so your partner had opened the center console?
Correct.
And you had stepped up and seen it still sitting there?
Correct.
And you hadn't previously looked in there?
No, because I detained Mr. Harris and placed him in my vehicle.
You didn't note in your report where the pill bottle was recovered, am I correct?
I don't recall.
Is it, you write reports that are thorough and include as much detail as possible?
I do.
You're trained to do so?
I am.
So if I told you that nowhere in the report does it say where this bottle was recovered, would you dispute that?
If you read the report, I would assume that you were correct.
Okay. And now you performed the traffic stop, right?
I did.
And oftentimes when I assume you performed many traffic stops in your role.
Yes.
And you're often looking into the car to see if there's any movement or any indicators of suspicion of the inhabitants of the car.
Correct.
And in this case, you didn't note any furtive movements from the driver or passenger?
Not initially, no.
Not initially. So not while you were pulling over.
Not prior to my making contact with the driver.
Yeah. And I know you said in your testimony today that Mr. Harris was a little nervous. That was when he was being arrested for driving while license suspended or detained, correct?
Prior to me placing him under arrest and being detained, yes, he appeared nervous.
Yeah. But at no point did you see him trying to conceal an object?
No.
No. And he didn't try to flee?
No.
He didn't resist you? And when this bottle of pills was found, you told Mr. Harris about it?
I Mirandized him and I asked him about it.
Mirandized him and you asked him about it. And his response was that he didn't know anything about these pills.
Correct.
So you don't need to weigh pills on a scale, do you?
No.
No, you can just count out pills.
Correct.
And you didn't find anything that would individually pack the pills in smaller amounts. You didn't find it in small baggies, for instance.
I did not.
The only container we found was the single amber vial.
Correct.
Containing these 56 pills. You didn't observe any sort of transaction, any sort of hand-to-hand drug transaction.
I did not.
You didn't observe the car going towards or leaving from a known drug house.
I did not.
You didn't find multiple phones on Mr. Harris.
I did not.
And there were no signs you picked up on from either Mr. Harris or his passenger that they were under the influence of a controlled substance, no?
No.
No. No one was overdosing.
Nope.
You took this bottle. Now, when you say it was taken into evidence, were the pills taken or was it the bottle as full?
The entire vial was taken into evidence due to the potential nature for exposure.
Now, do you know if any fingerprints were taken off of this bottle?
I do not.
Any DNA?
I do not.
And there was no independent source such as a confidential informant who is telling you that.
Objection, assuming that's not in evidence.
I'm confirming the lack of facts.
Objections overruled. You may answer the question, Officer Adams.
You never heard from a confidential informant that they were making drug transactions?
No, I did not.
Okay, I have nothing further. Thank you.
Thank you. Redirect, sir.
Officer, the amount of 56 pills, what is that indicative of?
Sales.
And who is the driver of this vehicle?
Mr. Harris.
When your partner initially saw these drugs, do you say anything to her in regards to anything in particular?
I advised her that they may contain fentanyl. And I advised her where my Narcan was, and I asked her where her Narcan was in case either of us were accidentally exposed.
In case, I'm sorry, I couldn't hear.
Accidentally exposed.
I'm sorry, just a little bit louder.
In case we're accidentally exposed to the fentanyl.
No further questions.
Thank you. Thank you, officer. You may step down. Thank you. Your next witness, sir?
No further witnesses, Judge.
Any witnesses, Mr. Martin?
No witnesses from the defense.
Argument, please. Oh,
Your Honor, we will move to bind over on all counts and we reserve argument.
Judge Martin, as you can recognize by now, this is a case where the prosecution would have to prove constructive possession. Not only constructive possession, but constructive possession with the intent to distribute. And there's just no indicia of that here. It's not his car. We have it, he borrowed his friend's car when they were hanging out, to go to the store and get some juice. No indicators that Mr. Harris had been using his car for any amount of time. No indicators that he's worried about something there being discovered. He's not fidgeting around. There's so many of the facts that you usually see in a drug dealing case that are absent. All we have is Mr. Harris pulled over in a car that was not his, and in that car happens to be a bottle of pills where there's no indication that he exercised any control over it. And there's no indication, not just beyond exercise control, that he had any ability to distribute or any intent to distribute that stuff. No transaction occurred, nothing happened in your drug house, you got nothing from a confidential informant, you have no means of individually packaging these pills. There's not probable cause here. If this were a possession case and all they had to prove was the constructive possession, I still think that's not doable because mere proximity is not enough. All you have here is mere proximity. But not only do they have to prove the constructive possession, they have to prove the intent to distribute, which they've got nothing to do.
Judge, this is a case where the individual did have the intent to deliver, and the facts show it. And they show it because a few things. The first thing is the amount of money he's carrying on him. Could he be a wealthy individual? Sure, that's plausible. But it's known for drug dealers, based off the testimony of the officer, that carrying that large of a sum of money alongside a scale usually used to, unless this guy is like weighing his food or something, but it doesn't, the circumstances don't really add up. 56 pills of fentanyl. That is a very dangerous drug. It's very dangerous to the community. And he may have not been the registered owner of the vehicle. That's fair. But you know what? When I was 16, I got a vehicle from my dad, and he was the registered owner, and I drove that car for maybe, 10 years. Now, it was my car. My dad never drove it. I drove it. He exercised dominion and control over this vehicle. He was the driver of the vehicle. He had the $2,700 of cash in his pocket. He had the scale, which is used to weigh drugs. Maybe it's for a different drug. But these circumstances all, they show that this individual is responsible for these drugs, at least the probable cause standard. I don't feel the need to delve into the danger of what fentanyl has on the community. I think the circumstances here show that this defendant had the intent to deliver, and these drugs that were recovered, that were in the vehicle of his vehicle at that time, where he was the driver of the vehicle, came back to be positive for the drugs, and the facts show all of this. So, Judge, we move to bind over on all counts. Thank you. And just to mention, Judge, sorry, this individual, he does have a clear disregard of the law when he zooms past going 15 miles per hour, over the speed limit. He has active warrants for his arrest. I mean, the idea of this individual having a clear disregard to the law, it's shown in the facts, it's shown in his history. So we believe that this incident is no different.
First of all, going 45 and 30 and having warrants for driving while license suspended has no bearing in any world on whether someone is possessing or intending to distribute drugs. The dangerousness of fentanyl has no bearing on whether Mr. Harris that day was trying to possess that. And in fact, we have from testimony from the officer, no one appeared under the influence, no one was overdosing. Seems like a suggestion that he certainly wasn't dealing it to the other passenger of the car. They weren't using it themselves. They weren't possessing it. And anyone can possess a large amount of money for any reason. This was this was 2.5 years ago. This was during the pandemic. This was around the time when a lot of people were getting stimulus checks that are often exchanged at checks cashed offices. So I had many clients who at that time had large amounts of cash on them, or from their own personal businesses, as we didn't get testimony. I won't speak to what there wasn't testimony of, but an explanation was provided. You don't have it here. You can't, there's no indicators of intent to distribute. It's just, he was in the same car, someone else's car, not his dad's car, who had been driving around for 10 years, his buddy's car when he borrowed from them.
Anything else, Mr. Mohammed?
Just briefly, Judge, nonetheless, this driver exercised dominion and control of the vehicle. He was found in this vehicle. He was found not in the passenger side, but in the driver's side. The amount of pills, 56, is indicative of wanting to distribute. The amount of cash, of course, alone is not going to show you, but that, along with all the circumstances of having a scale, having 56 pills, seeing all of these in totality, do show, at least at the probable cause standard, that the intent to deliver was there. So, thank you.
Respectfully, Mr. Mohammed, the court will disagree with you and will not bind Mr. Harris over his charge. That count 1 will be dismissed. The remaining charge is the driving while license suspended misdemeanor case.
Thank you, Judge.
So then, here's the question. Does the misdemeanor get thrown in the police report? So the misdemeanor will go on the Belleville pretrial docket next. Ask Heather or get the date for me. Give me 1 moment, please. No, that can't be right. No, because it's issued by the county. Is that how it happens? You understand what my question is? Is Heather here? I don't know. It was issued by. Is it you said January 3rd? Is that right? January 18th. January 18th. At what time? At 9 o'clock. Did she answer? No, she did not. The pretrial on the driving while license suspended is scheduled for January the 18th, 2024 at 9 a.m. with Judge Oakley in courtroom number 2.
Thank you, Judge. Do you know if Judge Oakley does misdemeanor pretrials by Zoom?
He does them in person.
All right.
Anything else, Mr. Mohammed?
Nothing further.
Anything else, Mr. Martin?
Nothing. Thank you, Judge.
Thank you. Mr. Harris, good luck to you, sir. Have a good afternoon. That does not feel right for some reason. Well, you know what? Then probably would stay on the Wednesday as a misdemeanor. That's why I want you to call her because I got caught. Yes. Mr. Jones? Thank you.
So I'll say the ones, yeah, okay, all right, thank you. Yeah, that makes sense. So I'll change it to-
Stop Mr. Martin and Mr. Harris, please. Thanks.
What date do you want to get?
2 weeks? It'll still be with Judge Oakley. though. Mr. Martin, this is on 230752 FY.
Mr. Harris?
Yes, I had an inkling that something, the correct date is December 20th, 2023 at 9 a.m. It's still it's on a Wednesday.
Oh, that's for his.
Oh, for the driving while license suspended. It's on a Wednesday. It's still with Judge Oakley. It's still in person. It's just 2 weeks from today
Oh, okay.
and not January
12:20.
12/20,
9 a.m.
9 a.m. Yes, sir.
Easy.
Thank you.
Thank you.
You too. Thank you. Do I what? He does. He's not in the same place. He's over in that white 2 or 3 story building in front of the Barrington. You know what I'm talking about? Right. He's in that white building with the big white columns out in front that you can see right on Wayne Road. I don't, but he has a sign out front on that big marquee. Take care.
No, it's only downstairs. So.
Yeah, no.
All the time. All the time. All the time. This is what cracks me up the most. And I just saw Attorney Hamilton. Yes. Yes, I didn't read it. Mm-hmm. Mm-hmm.
This next year's, but I can keep track of our felony days and our civil days and our arraignment days. That's why it's out here, actually.
Have you been doing that?
No. Because I've never had to sit still. I always had a paper calendar that carried everywhere with me, but now when I real quick have to say and keep track of where we are. Because like there's an R, B, and H and S on here for those days. Because I don't keep track of that stuff.
Me? Yeah. Oh, this is.
8 o'clock. 8 o'clock tomorrow will be here before we know it.
I'm gonna be here on the weekend, catch them all. No, I'm kidding, I'm just kidding. Oh, I know. They moved me to the office on the side, so there's on the side. And then the second I get it, the second I sit down, cold air starts blowing right now. Yeah.
Tim said full moon. Tim said full moon. That's not what it is, though. Full moon. Full moon's not for 3 more weeks. It's a Wednesday. Here's the thing. It's fine. You promise? Oh, that's the other thing. Marianne, I'm telling you.
Okay. I'm thinking about Michelle too.
Mm-mm-mm. So I just got a proposed order that has my name wrong. No, it's my name is just spelled wrong, which, I mean, not spelled wrong, it has the wrong name on it. It does not have my name as it appears in any court proceeding. So I'm just curious. I'm on base, that's what it is. You. Two, 30773 FY, State of Michigan versus Henry Jones Jr. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P 867.
And Vanessa Hamilton, P 82107, on behalf of Mr. Jones, who stands to my right.
Thank you, Mr. Jones. Today is the day and time set for the preliminary examination. In this matter, there is count one, embezzlement by agent or trustee between $1,000 and $20,000, larceny in a building. Are the people prepared to proceed?
We are, Your Honor.
Your Honor, we would like to waive our option for preliminary exam. I kind of explained what that waiver means to my client. And we would just ask that the prosecution put certain terms of an offer that we are waiving.
Does that offer need to go on the record before the waiver?
It can go on before, I prefer it actually go on before.
Absolutely.
Judge, it's my understanding that Bill Heafy, who is in charge of offering that version, has approved the version in regards to this case, and it will require a waiver.
Thank you. Mr. Jones, would you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. You may put your hand down. You've had the opportunity to discuss this case with Attorney Hamilton, and you understand that you have an absolute right to have a preliminary examination where the prosecution would have to show that a crime had been committed and that probable cause exists to believe that you were involved in the commission of that crime. And after having that conversation, you wish to waive your right to have that exam. Have you been threatened in any way or promised anything to get you to waive the exam? Officer Brooks is bringing the file to you. There's a place for Attorney Hamilton to sign and a place for you to sign. There's a place for the prosecutor to sign as well. Once Mr. Mohammed has signed it, the file will come back up to the court. The court is finding that you have freely and voluntarily waived your right to have a preliminary examination in this matter. The waiver form having been signed by all three parties, the court will now sign it as well. And Mr. Jones, you will be bound over to circuit court for an arraignment on the information. That will be your next appearance date in a courthouse. It will be on December the 20th, 2023 at 9 a.m. at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue. Is there anything else on behalf of the people?
Nothing further.
Thank you. That concludes this matter, Mr. Jones. You're free to go. You have a wonderful afternoon and good luck to you. Thank you. That concludes this court's docket for the day. We stand in recess.